Honorable members, good morning. And good morning to our guests. Welcome to Parliament. Good morning to our team from Parliament, stakeholders and members of the public. Good morning and welcome. So I just want to make sure that our guests are relaxed and you are welcome here. We are very grateful that you've come to assist us with this process. The way we'll begin is that Ms. Ibrahim is from the Parliament legal team. She will swear you in, but before she does that, she'll just explain the rules under which we are operating here and the privilege that you have in terms of your contributions to these proceedings, and then she'll swear you in, and then we will begin. I will offer further explanation of the proceedings thereafter so that I can orientate you around how we run the proceedings so that you are as comfortable as possible, all three of you. Ms. Ibrahim, over to you.
Thank you, Chairperson, and good morning to yourself, the Mayor. 2004, read together with National Assembly Rule 168, which affords certain privileges to witnesses to appear before the Standing Committee on Public Accounts as a witness in respect of the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court of law or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. Mr. Phillips and Ms. Mthethwa, you both have indicated that your preference is to take an oath. Mr. Phillips, I'll start with you. If you could please raise your right hand and repeat after me. I swear that the evidence I shall give.
I swear that the evidence I shall give
shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
Thank you, sir. You're now duly sworn in. Ms. Mthethwa will do the same. If you can please raise your right hand. I swear that the evidence I shall give.
I swear that the evidence that I shall give
shall be the truth.
shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
You're now duly sworn in. Thank you, Chairperson.
Thanks very much, Ms. Ibrahim, and to our guests. So let me just explain. So this is not an accusatorial process. It's inquisitorial. So it's a fact-finding exercise to assist us with our oversight role as Parliament. So we need to develop as proper an understanding as possible for lay people who don't work at the Road Accident Fund, so that the recommendations, the observations we make in our report and the recommendations that result therefrom are accurate and they are useful. They're useful to the Road Accident Fund, they're useful to the Ministry of Transport, they're useful to government as a whole, and they're useful to Parliament. What we are particularly interested in doing is making sure that we have a system at the Road Accident Fund that is accessible, that is user-friendly, that is efficient in terms of how it operates, that is cost efficient, which links more closely to our mandate. So if you get these three right, you get to cost efficiency, so that the little money that the Road Accident Fund gets can stretch as far as possible. So that's where we want to end up. I also want to say that what helps the committee is for you to say what is in your personal knowledge. So if you are not certain about something because you heard it, you can just say, listen, you'll have to ask someone else, I'm not certain. Or you can ask people in this department that question. I wasn't dealing with it directly. If you heard something, you can say, I heard it, but I'm not an expert. You know what I mean? So don't feel pressured to answer questions that you genuinely are not able to answer. Similarly, though, it is important that you don't omit information that the committee really needs in order to make accurate recommendations, right? The way the process works is that at the draft report stage, anyone who is affected by a conclusion of the committee, we share that information so that you can say, okay, this is not accurate. It's not actually 100,000. It's 200,000. You know what I mean? So you get an opportunity to make comment on the draft report. So don't stress, just relax. Try and use simple language because we don't work at the RAF. So Mr. Phillips, you're a lawyer. Right, you know those Latin words. We don't want them here. Okay. You can say it, but you can explain to us what it means. The members will not feel patronized at all. Okay. I also want to say that even though today we're dealing with, we're not here to tell the Road Accident Fund what strategic choices it should exercise at any point, right? We are here to make sure that the strategic and other decisions taken have a positive financial implication rather than a negative one. And it is in that context that we would ask questions, right? So I think that's important to say. Mr. Phillips, thank you for preparing some slides for us. I will start though, because what we try and do, so the members have got an affidavit from Ms. Mthethwa. I understand the two of you have worked together before, so you know each other. And your roles basically intersected, right? So it's a complementary sort of a conversation with the committee in that there might be issues that she addresses, but you would be better placed to deal with, and vice versa, and so on. So let's just keep it like that. That means if Ms. Mthethwa gives an answer and you feel that there is something that you need to add in order to give the committee a full picture, and vice versa, you really can say, Chair, may I add? So that's what some of your previous colleagues have done when they come to the committee. That's usually helpful to the committee. So don't be afraid that we are going to stop you. We want the information, right? So what I will begin by doing is just, I said to Ms. Mthethwa before we started that I'll ask you about 8 questions just to draw out some key aspects. The first 2 or 3 are really basic about what's your job and that kind of thing, and then just bringing out some key issues. With you, Mr. Phillips, it's a little bit easier. There are some slides that I've said you can show to the committee. We'll give you an opportunity to just take us through those slides in that they relate to the terms of reference. But what would be important before you begin is to just say, when you join the RAF, what is your job? What have you been doing to bring us to the point where you're getting to that beginning slide? We will appreciate that, and for the public it will also be useful. So I'm going to start with Ms. Mthethwa. Because you've got a presentation, yours will be quicker. I won't be asking you questions, you will just talk. And then once we are done with that, each of the members will get about 15 minutes for a direct exchange to answer the questions. It's important to be as concise as possible. So don't feel the need, both of you, to over-justify yourself. If the member is not happy with the question, you got time, they will still say, please say some more, right? But I appreciate concise questions, because when the member's time expires, I then cut them off. So long answers don't help members, right? In that the member ends up with 2 questions only, and then the time expires. But I really want to encourage you to relax. It's not an accusatory process. Speak as if you're speaking to people you work with, and explain things very simply. Is that okay? All right. Thank you very much. Ms. Mthethwa, I'll really just ask a couple of questions. Just tell us, in short about your history at the RAF, the work you've done, and what your last role at the Road Accident Fund was, so that the members we can establish your personal knowledge of some of the factual issues that we'll be dealing with.
Thank you, Chair. My name is Christina Mthethwa. I joined the RAF 2014 July as originations manager. This is when the actual implementation of direct claim strategy began, as the fund opened 5 customer service centers, which I will refer to CSCs for a brief. So I was employed and I started my work with RAF in Limpopo province, managing and heading direct claims originations in Limpopo province. That was from 2014. And this is actually when direct claims was established. I'll go back to explain the details there. Then later in 2021 June, I was then seconded to the Johannesburg region as acting actually when I was seconded, it was to assist with the implementation of the new business model. And then upon arrival, I was then requested to act as a senior manager litigation. I will take the members briefly on what we did as direct claimants and why was the need for direct claims department within the RAF. On the history and knowledge that I have on how I was briefed, how we were driving the strategy, the department comes about because the organization felt a need to assist with reduction of legal costs. Our department dealt with assisting the victims of MVA to claim directly with the RAF. So we were there as the representative internally for the RAF, and we assisting the victims to understand and to get the first hand of how to claim directly, what benefits are accessible when we claim directly. I will go through my affidavit just to state other things that are right there. So as a manager, I was responsible for overseeing the smooth running of the Provincial Claims Originations Department by ensuring compliance to the legislation, policies, and RAF procedures. My duties included development and implementation of the business plan, aligned with the RAF strategic objective, which at the time was direct claim management, as well as management of the hospital service consultant and mobile offices. So in my team in general, we had employees that were based in the hospitals that we call them hospital service consultant, which I will refer you to as HSCs. And we had mobile officers. Those officers, they were responsible for us to give instruction to go and collect whatever necessary information for us to assist the direct claimant to lodge a claim. And we had administrative team within the CSC. It was a working center, and at the same time, the claims lodged within the province. We will register them in the province, we'll check compliance in the province. We will also confirm liability of the fund, which we call merits department. Once that is done, then the claim moves to the region, which we will report it to the mainland region. So the overall activities and functions of originations, after the accident has taken place and there is an injured, our teams will then be the first point of contact when you enter the hospital. In Limpopo, we were in 17 hospitals, and some of the officers also supported where our visibility was absent, where we did not have an office. So you'll find that some of the HSC's offices will be running with 2 or 3 hospitals in assisting the victims. Where there is mass accidents, we will then go to attend to that accident scene as we're an extended arm of the government in terms of support. So we will attend to that, ensuring smooth reporting as well as easily accessible to benefits of the RAF. Now, I will just go through the legislative backdrop and the strategic context of direct claim.
Sorry, so you've set that out in your affidavit,
Okay.
and the members have it. So you've explained the context of direct claims, because it's the first time you are kind of hearing the color of who did what. So in other words, you are kind of getting into the space where the ambulance chasers usually are, so that those people can then deal directly with the road accident fund, and having knowledge of a particular accident helps with the verification, I suppose. That's what I'm understanding, that yes, there was a person accident, yes, there were 65 people injured, they were taken to these hospitals, our people are in those hospitals, and their access to records. Okay, so I guess, so the origination is in that you are the ones who are acquiring those people. Would that be correct?
That's correct, Chair.
That's correct. You're the ones who are okay. Can you just tell us then the rest of the process in short? I mean, it then goes through, let's assume everything is in order. What happens towards conclusion?
All right, so what will happen? Firstly, we will assist the victim after we've explained, of course, the benefit, and the victim opts to claim directly. We'll then assist the victim to complete the RF1 form, because you don't understand this form, so you will need assistance in completing the form. We will then ensure that we collect, because the victim at the time is still in hospital, we will then assist in collecting all the compliance documents. At the time, not under the current regime, at the time, it will just be an affidavit. Because of the hospital records are not ready, the victim is still in hospital, we'll then ensure that the section for SMR, statutory medical record, report is completed and signed by the admitting doctor or the treating doctor as confirmation that the hospital is aware of the victim, and also confirmation of injuries because of the medical records are not yet ready at the time. And then we will collect the accident report on behalf of the victim. We'll get the ID, make a copy and get it certified. Where in areas where we had a strong relations with SAPS will also assist us in commissioning affidavits while the victim is still in hospital. And that file then will be ready for us to lodge for the victim. Now, how this actually assisted the victim is that we were getting ready that by the time this victim exits the hospital, the organization then implemented what's called an agent undertaking, which did not exist prior to the direct claims was established. Now, the agent undertaking assisted us that when we then assist the victim, we then make a request through the case managers, because we also had the case managers that were based in the hospital within the province. The case manager, which belonged to RAF, will then draft a report that will accompany the file, and then will then request an agent undertaking as we process to those files. So those files for serious injured people will be marked agent undertaking. So that means we'll treat them in priority, that do not wait in the same process with other files that are only going through just for compensation. Because of now, we needed to settle the undertaking for agent treatment of this victim. So the agent undertaking then ensured agent access to other medical treatments post-discharge. So in a way, we will start preparing for rehabilitation before the person gets out of the hospital, and not to wait at the end when the claim gets settled. So that's basically the process that direct and agent support will be giving to people with serious injuries. Once then the file goes through to main lane, the handlers, when they assess that file, will be different. They will start off on the aspect of issuing this undertaking certificate, which then works as a commitment by the RAF for payment of other medical treatments or rehabilitation or appliances that are required by the victim other than the compensation. So the first focus then will be that aspect. And then once that agent undertaking has been finalized, it's sent back to us in originations or the case manager. Then the case manager will then hand over these aspects. So what basically happens, Chair, we'll have a chain of departments, and how they work together, it was linked. So we'll have originations that originates the claim. We'll have the case manager in hospital that assists in assessing the seriousness of injuries. Then we'll have the back team in the CSCs that will then assess this file and send it through for agent undertaking if that is required to direct claims department that is now based in the region. Those are the handlers that actually assess the file. When those people are done with the assessment for agent undertaking through the assistance of the medical team, they then issue the agent undertaking that goes back to the case manager in the hospital to hand over to the field case manager. So the field case manager now, they deal only with the portion of post-settlement rehabilitation. Now, the field case manager now, I think I've mentioned about now four teams. The field case manager will then assist with now taking care of the victim that's got nothing to do with the lodgement of claim. So that's basically was the process at the time.
No, thank you very much. So I just want to tease out some terminology. So when you say, for instance, so I just want to understand the urgency. So if Honorable Matuna over there has only broken his thumb, but Honorable Ghana on the left here, he's broken both legs and he can't walk. So Honorable Ghana becomes a more urgent case because he might need others. So that is, am I correct? So
Correct.
in that Honorable Matuna is fine. He can't press his smartphone. That's the only thing, but he's fine. And then when you talk about rehabilitation, I just want to be, so that people don't think drug rehab, it's the physios and the like thereafter. So just explain the rehabilitation portion. So that's one. The second thing, maybe what you start with, just explain the undertaking letter. What does that thing say? How does it benefit the claimant? And then go to the rehabilitation aspect of it. And then we'll just get to, so when does this end? What do you move on and do next, etc. And then we'll hand over to Mr. Phillips.
Okay, one of our core focus was the integration of the injured back into the community as much as possible. So, for instance, if Honorable Maduna's broken legs could be healed as soon as possible for them to be reintegrated back to the community or back to their workspace and do the things they used to do before the accident. So what will happen is, this focus that we did, we were trying to reduce the possibility of complications, of further complication caused by delayed to access to treatment. So that's basically was the role. So if post-accident, he goes to the state hospital because it doesn't have a medical aid, and in that process, the state does not have capacity to treat him in the next 3 or 4 months. In that period, your fractures gets complicated, possibility for you to be healed better had it been attended when it was fresh, they might be slim. So now, with the undertaking certificate, what we call it rehabilitation, that integration back will be that we then, after you are discharged, the case manager then starts planning who are the specialists available to treat you, whether it's the state or private hospital. If it's in the private for you to get the best services, they then go out, orthopedic surgeon, get us a code, let's submit it through, get it approved, then you do the surgery as soon as possible. That was just to help with other aspects other than just assisting the victim, was also a strategy driven by the business to also try and manage the future risk of these injuries more further, with also compensation that escalated because of this person actually complicated because they did not access proper treatment as soon as possible after the accident occurred. So that was part of the rehabilitation. Second part of the rehabilitation, some of them you find that they are paraplegics. spinal injury, you can no longer walk, you are sitting on the wheelchair. From that accident, that is firstly a traumatic experience. You need psychological treatment. Secondly, you need to go to the rehabilitation center now, where they're going to help you until you actually discharge, because the hospital does not keep you with the rehabilitation, but they only treat you to stabilize you, that you get treated and discharged. So for those issues, then the case manager will then look for a rehabilitation, we call it a step-down facility or a rehabilitation center, where now the victim will be moved to that facility to be trained how to use a wheelchair. How can they be mobile? How can they do things by themselves, considering the injuries that they actually now, the situation they are in? And then with that, then the case manager in that whole process, as part of rehabilitation, the case manager will then start working also on the family part of the victim to say, now this person going back to the community, how are they going to be integrated back to their space? At home, is the space okay for them to use the wheelchair? Can they go to use the shower that they were using? Is the door open enough for them to go in? Then they will work on those quotations as well. That is going to be structural modifications for them to be ready to go home. Appointment of the caregivers, those discussions with the family to bring back this person and actually manage to cope with now the disabilities that are there. So all that form part of actually what case management did after we had lodged the claim. Now, with the agent undertaking then, it pays, because now when the person leaves the hospital, let's say to the rehabilitation center for the training on mobility and other things. Now, the person, when they leave the hospital to the rehabilitation center, they will then have an authorization that is approved for that admission. Now, this falls under the controlled risk, where now everything is controlled. The fund is not surprised by, I've just received a claim, because the receiving of claim should only be under where a person is not yet admitted, an agent admission, not post-admission.
No, thank you very much. I see how we could have dealt with the two members differently. The one member with a thumb and the member who is immediately able to go home and go and watch shifts on the next day. So. You see, you know this committee is supposed to deal with serious matters, but you get members. I'll give you 5 minutes each. Carry on like that. I'll give you 5 minutes each, ma'am, and give 30 minutes to Honorable Pila. She always finishes on time. Yeah. So. Anyway, no, we don't bite, as you can see. I know sometimes COPA is this place where you're going to get hung. Relax. So Ms. Mthethwa, then in your affidavit, you then say there is then a change to this whole thing. What changes and how is this whole process? What changes?
Okay.
And how is this whole process, does this then affect the processes, the change affect the processes of claims and so on? So just take us through that. But if there's a piece of information that's important before we get there, you can share it. But we're just trying to get the story out. Okay.
I'm just, before I come to the change, how we worked, we had targets that were set. And these targets will be approved by the board, cascaded down to executives, all the way down to the lowest level of a grade that is working within these objectives. So when we started off 2014, I think our target were around 22%. And it moved all the way to, I think by the time the department was closed, we were sitting at around 28 or 32%, somewhere there.
Percentage is always relative to something. 22% of what?
22% against represented claims that were lodged.
Oh, I see. So you were trying to move as many claims as possible to go through the process without somebody having to go through the court process.
That's correct.
All right, I get you.
So our targets were moving targets that were increasing. So from 2014 to 2020, you will see that our targets were increasing. If we look at my paragraph 30 on the affidavit, you will see that we started off by 22,524 direct claims, and it moved to, by 2019, annual report, it moved to 40,986 claims that were lodged directly. And this actually, it interprets beyond the figures that we are giving, because you're looking at how much was a claim could have costed the organization had it came through legal representation. Now you're talking about the legal costs. It might look like a small number, but it's actually a very big number compared to what could have been if this was already, because before the establishment of direct claims, the awareness campaigns had already begun to try and inform the public about the road accident fund, what we do and end. So the numbers were already increasing, because if we look at the 2013-2014 financial year report, you could see that there was already a 10% of direct claims, but not under the strategy. So it basically, that's what it interprets to. Now, we will have targets. For instance, Limpopo region had actually the highest number of claims lodged because of its one province with the highest number of accidents that are happening, hence the highest number of claims. So in 2021, January, we then received an urgent call for a Teams meeting, where we were then informed to stop all activities relating to the direct claims originations.
Sorry, repeat the date. The members didn't quite catch the date.
2020, sorry, not 2021, 2020, January. We then receive an urgent meeting request via Teams through our senior management in the region mainland that we needed to stop originating direct claims or activities relating to direct claims, but only assist if they walk in. And that's how we're going to help them now. So the discussions became strong that we asked, then what do we do? Because we have, I mean, this structure came with a lot of investment.
Sorry, can I ask two simple questions? One, so who is presiding over the meeting, and do they explain why this must stop? Because the story you were telling us, we were laughing at it because, like I said in the beginning, you want a process that is seamless for the victim, right, who suffered trauma and so on, that basically I don't need to wait for a court date. Either to settle the whole matter or to, you know what I mean? So it goes through the system and eventually it's sorted. By the way, I just need to share a story with you, Ms. Mthethwa, my best friend. We were in our teens. He was hit by a motorbike, broke his right leg. Was a talented sprinter and soccer player. And he went to Mthethwa General Hospital. I think they missed something in the x-ray, but they put cement on him. Plaster of Paris on his leg. Came back, he was back at hostel on crutches, and then he started leaking on the cement. You know, he was clearly bleeding, you know, and his leg had to be reconstructed later. This is 90. He still walks with serious limps, never been able to play sports since. So I appreciate the value of what you are saying in terms of making sure that, I mean, we were in the homeland then, there was no RAF. But the point is, I can see these cases that you are talking about. I really appreciate that there was an effort to make sure those kind of things do not happen, because he then ended up with those pins and things to keep his leg together and so on. So anyway, I just wanted to say the work that you guys were doing and the RAF that it does in that sense is really important work. I really appreciate that. But can you just tell us, so who convenes this meeting?
Okay.
And do they give any reasons why this must now change?
We were in that meeting. It was our regional manager, RGM. It was Mr. Mthethwa, and our senior managers were also present in that meeting, which is Mr. Mthethwa and Mr. Mthethwa. They were all present in that meeting, and us, the management, also were part of this meeting, because we had a CS under the mainland region. We had CSC in Mpumalanga, Northwest, and Limpopo, as well as Gauteng North, which is your Pretoria, Tshwane. So we were four offices reporting to the mainland region as originations. So with other regions, we had the CSC in Bloemfontein, Kimberley as well. All these were established because the whole aim was to access the most furthest areas to the points of service. For instance, you will expect a person coming from Musina to go and make an inquiry or lodge a claim or actually follow up on a claim in Pretoria, or a person that is in Bloemfontein to go to Joburg office, which is actually very far. So we're reaching the most outskirts areas within the country, as you're saying, your friend is from, yes. So that's basically what's the concept. So we get this information, then there's nothing in writing that we then need to, is this a new development? We needed to stop with lodgement of direct claims or going out to get direct claims. We then need to stop and be in office. We can only assist with walk-ins. So that's just as far as these instructions was conveyed to us. Nothing other than the meeting or any communications, nothing at all. Then in February 2020, we then asked to withdraw our resources from the spaces where they are. That is now the hospital consultants that are out there in the hospitals.
So you were asked to withdraw them, or you asked to withdraw them?
We were asked to withdraw them, and we actually did exactly that. We then now engaged the team to say, there is this instruction. In terms of where to, we also don't know, but the instruction is we need to stop marketing direct claims, because what we did basically, we're marketing direct claims. We will hold road shows. We'll have a calendar of activations we're going to do within the communities where we operate in, and those activations will be budgeted for by the organization. So there's a whole annual plan to the end of the financial year end, which is end of March, that we actually have in place. So all those things had to stop. We then had to just process claims or only assist the victims that come through the door to inquire.
So that means the people that were going to accident scenes, the people that were at the hospital, making sure that all the records are proper, assisting the victim and so on, you had to tell them they can't do that anymore.
That's right.
You will only assist people who reach out to you.
Yes.
Okay. All right.
And at the time, actually, it's just that I looked for this form. I could not find it, because now this has been a while. We were even drafted some sort of a consent form. So prior to this ending of direct claim, we were using what's called, it was like some sort of contracting with the client. It's called a consultation form. So in that consultation form, it read the rights of the direct claimant, and it also gave when the claim is going to prescribe and who assisted them to lodge the claim, and both the client and the RAF officer that lodged the claim will then sign that consultation form. So at the time, we're given something's called, I think it was a consent form, for a better word. So with that form, the client will be saying, they will basically taking an oath in a way that they are claiming directly without an assistance of the road accident fund. So it's basically just to distance us from this lodgement.
Okay, so in the event that a person wanted to use an attorney or something, then that would be their choice. So
That's
you were
right.
not forcing them to work with you, but if they don't want to work with you, they must say, I would prefer to something that Honorable Maduna would do. So they would then run their own process.
Yes. So basically, yes, Chair. That will be so that consultation form worked for that to say we will know who assisted the client, were all the rights explained, and was it noted when the claim is going to prescribe? Because when you do the first consultation, it's before the claim is lodged. So this will help us as management in case for future complaints, future inquiries. The victim will come with this document to say this is the person I spoke to and this is what was explained to us.
Okay, so I just need, can you switch off your mic? I just need to make a request to the Secretariat because I am not certain if this was distributed to the members. We did ask the Road Accident Fund to provide us with information relating to direct claims. So I'm not sure, Denzel, if it was sent, but could you please, just for completeness, send it? It's a short email, it's a table. We asked them to give us since 2018-19 direct claims in number as well as a proportion of the total claims. So if you can just email it to the members if it wasn't. So we've got that information will be available, but in 2018-19, 36,200, 2019-20, 33,010, that was 32% of claims, direct as a percentage of all personal costs. And then 2020-21, COVID might have played a role. It fell to 4,620. The number has been declining since. It became 2,052, 3,398, 2,894. In 2024-2025, this financial year just ended, 2,819. They now comprise 14%. So that's fallen from 35% in 2018-19 to 14% of claims. So if we can just send that to the members, because it then also kind of completes the picture. There's other information there, members, that will be useful for our questions later on. Okay, we almost done with you, Ms. Mthethwa. So we just so you've now explained that, and the reason I'm saying let's distribute this information, we can also see the impact. But what I wanted to ask, what happens to those people that were doing all of this work? Are they retrenched because you had hired them to do a specific task? Where do they go, given that they can't do this work anymore?
In Feb, when we did that now second instruction to withdraw them and reallocate them to other duties, some of them, for instance, if I had an officer that home is Northwest, I then transferred that person to the CSC Northwest because now they're doing the back office admin work, will assist them. Some were transferred to Main Lane office because their homes are around Pretoria. And the ones that are furthest in the district from the CSC, they then relocated. So we gave them time to relocate to the CSC and work from the CSC because now the hospitals were closed. So they are still there. They're doing the admin work, support work to the region. That's the files that are being processed in the region. So they just become an extension for the region and also deal with inquiries within the province. So basically, that's what they do.
All right. Thank you very much. There is then, we can deal with the rest in questions. I'm sure the members have got lots of questions. I just want to understand around the change in your role to litigation. What brought that about? What was then entailed in your job? And what operationally did you observe in the processes of the RAF as it relates to litigation?
All right, I would like to go to my affidavit where that is concerned. So in June 2021, I'm actually approached in May 2021 to go and assist in Joburg with the implementation of the new business model. So the business one is now introducing as far as a consent at the time.
Excuse me, I'm sorry, Chair. What page are we on, Chair?
Just give us a paragraph number. Or
I am still going there.
Okay. Oh, you still, but
Yes,
just find it first.
Okay.
Tell the members which paragraph it is and then speak.
Okay.
As you can see, we're nearly done.
this is rehabilitation. Now I'm lost in my own affidavit.
Which bit are you looking for?
June 2021.
So you might be looking at paragraph 90. From paragraph 90, which is on page 21. Could I be correct? Because I was asking you about the termination of panel of attorneys and operation. Is that where you're going?
Yes, I think this will be where we are.
Okay, maybe if you look there.
All right, so in I want the exact paragraph. That's 96. Yes, 96 in June 2021. Yes, 96. I was requested to act as senior manager litigation to help manage litigious claims following the termination of the panel of attorneys. So the panel, as far as I understand, it's terminated in June 2020. Then 2021, I am requested to go and assist with the rollout and implementation of the new business model in the Joburg region. The terms of secondment were not very clear, as I was told I'll be assisting in the litigation department. So the actual terms were not very clear. But when I got to the region, I was then requested, actually the following day I arrived. I did not actually do the duties as I was requested on my secondment. I was then requested to assist, to act as a litigation manager, senior manager litigation. And I did raise the fact that I do not have the legal background. I do not have legal qualification. I've never worked in litigation. But there was confidence in the request based on my managerial experience, because they needed a person that's going to actually lead and guide the team more than anything. And I was assured that the necessary support will be given to me when it comes to litigation issues. Then, yeah, that's how my responsibility started. I must say that when I actually go there, it was a chaos. The files, because at litigation, you have a mandate to sign the memorandum for the offer. So the senior manager's mandate limit is 3 million. So that's basically what I had to commit myself to. If it's anything above 3 million, then that means I need to then support the request, and it goes to the highest authority in terms of the mandate. Yeah, there were files, like piles of files, waiting for these mandates to be signed so the handlers can issue an offer. So what basically happens is, before an offer is issued, there is a memo that is drafted to justify. It's like a motivation, to put it in a layman. So that gets drafted for the approver to consider that this offer can be accepted, and based on whatever supporting documents that is on the file. Yeah, so we started on that project. It was long hours while we clear up the backlog. And so the most crucial issues that I observed was the way these people were working on the ground, the handlers. The handlers, when I checked why so many files waiting approval, why so much escalations and complaints that are being handed over, and what's happening, because now I had to go through and check where are we in terms of offers, because at the time I didn't understand the model, how the whole process worked. So what I picked up was that each officer had about over 1.5 claims in their profiles.
1,500.
Over that. Because of those that, then I am told, no, there are officers that have been dismissed, they cannot be replaced. Now the portfolios of those officers now had to be shared amongst the existing officers. So it was some sort of an issue of shortage of incapacity. And at the same time, the workload is just coming through. And on the other side, they had trial matters that are going to court, and there is no one to go and defend these matters. So it was an issue. I just could not. Firstly, I'm not a legal person to understand the issues of trial, the matter going to trial, what the process it takes for the matter to go in trial. So people were just chasing what comes on the table. So if your matter is not on trial, so be it. If the matter is on trial, then it gets chased. And in most cases, we'll be working on the matters that are going on trial today. Not a plan of we planning that there is a matter we received, it's going to go on trial. No, it was quite a messy situation for a business as huge as a regional office. I mean, I'm from the CSC where everything was orderly, so I hoped maybe because of the capacity and the structure of our work. But in this case, you're expecting a streamlined process to manage the risk as far as the files are concerned. I then communicated with my other colleague, Surprise, in the regional office.
Surprise is the name, right?
Yes.
So they were not surprised. Surprise was
Is the name.
Okay.
Yes. Just to check how they work in the other side, as now it's a regional to regional office in this new concept. And then I'm told, no, Christina, with our capacity, that's just impossible. We are chasing what's going on trial. Okay. Now needed to be a plan because of you are working on the matter. If you are given a matter that's going on trial today and that's 8 million, what then do you do? That was a problem number one. Because you cannot assess a matter that is 8 million where the mandate of approval, it's in head office. It's not in the region. 8 million needs to be approved by the CEO. 5 million needs to be approved by the COO, not in the region.
Okay, so when you talk about mandate, so in other words, I just need to understand the numbers and the mandate. Do you mean in terms of settlement?
Yes.
So in other words, the matter is in court. The attorney who's representing the Road Accident Fund would have a mandate. So let us say, I don't know, let us say the claimant wants, as Honorable Beasley would want, 23 million, right? And the attorney has been given a mandate to settle up to 8 million. But that number needed to be approved at the right level, at 8 million level, which then is not you at a regional level. It now needs to go to head office, basically. Is that what it means?
It basically, what it means is the attorney will have his proposal on how much he thinks his file is worth. Now, based on the medical legal reports and the actual reports and the injuries that are there, the file then gets assessed to its correct value. Now, that correct value that we come up to, then that becomes the limit on that mandate.
Okay, so I'm now trying to pull together other sort of information shared in their thing. So basically, somebody has to quantify the claim. They look at medical legal reports and all of this stuff. They know the matter is coming up on the 26th of November, as an example. Then the RAF takes a position to say, sort of at the expert level within the organization, colleagues, this thing is not worth more than 8 million. It's 8 million. We're going to go to court and we're going to argue in court that this 23 million Honorable Beasley wants is inflated. Our position is 8 million. Somebody in the organization needs to look at this recommendation and say, yeah, it's fine. You can go and defend 8 million. So if the matter is settled at 8 million, you don't need to come back here. It's fine because we are happy. Is that what you mean?
That's correct.
Okay, all right.
So as an approver, then you're going to sign that memo and approve that offer can go out and if it's accepted, then we proceed. If it's not accepted, then the attorney can either then proceed based on the client's instruction to court to defend why they want what they want. Yes. So now the challenge will be if this matter gets to me in the eve or in the morning of the trial, what do I then do? Where do I start? Because I as an approver, I have to go through the whole file as well, including all these other medical legal reports and all other reports to satisfy myself that the offer is actually okay. We can sign it off, or I can even reject it and say it's exaggerated based on my own how I've assessed the file and the opinion. Of course, I won't be sitting alone. I'll be sitting with the other, whether it's the manager or the senior manager, or for instance, at the time, Mr. Phillips. We're working together. We were working.
10 will come, Mr. Phillips.
He joined us later on in 2021. December? November, yes. I then saw a need that we need a person with an experience that actually can come in also as an advisor for the department. So when we went for that interview, it's actually we're pushing, because I started in June, and by November we already had appointed Mr. Philip, and he joined the team. And through him, it was huge help on all these gaps that were there within litigation. So that was the chaos that was there, and now I come there. There's also a second issue of a handover, or yes, from a PA, I'm given a list that this number of employees must be suspended and disciplined. Reasons being matters 180 days not requested and default judgments that were not requested. So, but the main issue there was the matters not requested payment within 180 days. Then we had to also investigate those matters. When you investigate it, then you find, but it's just not practical for an officer without help. They have files in their portfolio that needs to be assessed and offers to be issued. They have inquiries, because of now there is no panel. So before we will know, as for the handover that I received, they will know which file is with which panel of attorney. So that transition between the panel and the implementation from the business side, it created a very huge gap, according to my opinion. Because of now, you have an officer without the support structure. The officer that is assessing files for office, and at the same time, they had to handle matters that are going on trial. There is no team that specifically is dedicated to the trials. There is no team that is dedicated to us. You know, with my little knowledge, when you receive summons, you've got a turnaround time on when to respond to this summons so that it can be defendable with the attained legal language. So we have summons that were never even looked at, and that's like a year later or 5 years later or whatever. You have, because of the attorneys, the plaintiff attorneys, they need to work on these claims of their clients, and the process is by way of summons in the legal language. It's by way of summons. So I am told if summons is not, by the time you come and try to negotiate with the attorney when there were summons that were not defended, then what? It's a situation of lose, or somebody will have some empathy on you. So it was all those issues and the stuff that had to go and stuff that are already gone and they could not be replaced because there's a transition to the new business model. So that was this whole chaos that actually brought the issues where we ended up where we are. So with all that, we then, together with Mr. Phillips, we then came up with a complete new structure within the department to try and mitigate all these risks. We then had a team that only...
Sorry, there's something I'd like to address.
Okay.
In paragraph 103 on page 24,
Yes.
do you have Ms. Mthethwa's affidavit? Can we get Lungisa to provide Mr. Phillips and his colleagues with so that you're not sitting here lost? My apologies. We'll sort you out. Thank you. Because you guys work together, so you also need to add or clarify or whatever in various aspects when your opportunity comes, especially during question time. So 103. Regions were effectively given a number of people required to be suspended. Can you just explain that? I'm not sure how somebody who's outside the region can give you a number of people rather than names. I don't know. Just explain that to me.
Actually, the number had names. So the number had names. So I do not have a full background on this issue, how this came about, but it was names of employees that had the highest number of
cases.
cases.
Right, I get you.
Yes.
Okay, so basically, I'm trying to get us to the end so Mr. Philip can do his thing, and then we have a conversation with the members. So basically, my understanding is the panel of attorneys is let go. Is then replaced by state attorneys. First question, how many state attorneys are you aware? How many there were? Available? Mr. Philip will deal with
He'll
that.
speak to that, yes. He'll speak to that. What I know is when I arrived, there were state attorney. I'm not sure if they were actually state attorney when I arrived, but I think they were appointed when I was there, because you found some, Mr. Phillips.
Okay, let Mr. Phillips just...
But at the time when I arrived, I was told the state attorneys do not yet have the right of appearance. That's a year later. The end of the panel of attorneys. They did not have a right of appearance. So we just had to see how we... some judges allowed us, even though we do not have that right of appearance. Some judges, the state attorney will just sit on the bench. If the judge does allow that they say something, they won't. Because some judges, I think they just carry that sympathetic outlook towards
Mr. Philip is a lawyer, right?
Yeah.
So he will explain
He
those
will
things, so don't
explain
stress about it. No, Mr.
Yes,
Philip will
yes.
get an opportunity.
So-
I just wanted to just understand that. So there are people with a heavy caseload. So it appears that the heavier your caseload, the more likely you were to be suspended.
That's right. So if you had, let's say, 40 cases in your portfolio where there were court orders, payment of request was not done, but this now was over 180 days. I think there was an arrangement with RAF for this 180 days process. I don't know how it works because it started before I go there. But officers where matters were not requested beyond 180 days, they then had to be suspended and disciplined to be dismissed. And there was a list that I was given when I arrived. But going in and checking, because I mean, as a manager and the policies of the organization, you cannot just go and charge a person and discipline them and dismiss them without actually to understand what actually transpired. So only to find that based on this whole overload that's happening, there is no structured way of working. There was no mitigations in place to support the employees through this abuse of workload. There wasn't. Now, you're expecting an officer with over 1,000 files on their desk or on their portfolio, with inquiries from attorneys that are coming through, as well as the trials that are going through, for them to also pick up in one of these thousands of emails they have, to pick up that there is a payment request or there is a court order that's through. So there was no proper process in place to manage and ensure that these officers are supported with all these things that are happening. But unfortunately, no excuse will be accepted. These people must go, and there's nothing we could do. So then the people had to be charged and they had to go, and we can't replace them either, because now we are working on transitioning into the new business model. Now you are left with this workload. Some people are gone, and you can't replace them, and we're not even coping with those people that are there. And yeah, you will see to finish.
All right. Thank you very much, Ms. Mthethwa. So I just want to, and if this is something, I don't want to make an assumption. And if you are able to deal with this, Mr. Phillips, when we talk to you, you can address it then. I am just assuming, because one of the things we are trying to understand is now, with the benefit of hindsight, the cost benefit, right? So if you're telling me that in your recollection, the panel of attorneys is terminated, the state attorneys don't yet have the right to appear before the courts, that takes some time before that is concluded. What happens in the court by way of how the matters conclude? Is that the space where we begin to see the number of default judgments go up. Are you able to make a comment on that? Because I'm assuming if the matters are now undefended, the claimant will then get the money that they're looking for, even if it should have been less.
I will make a comment, but Mr. Phillips will go deeper into it because he understands all the jargons and processes of how one obtains the default judgments. But what we've picked up when I questioned on the defaults that came to my desk, default judgments, court order, mainly it was because, one, they did not attend to the interlocutory trial, and those matters then eventually decisions were taken that they are going on default, and at the same time we did not have capacity to go and defend. That's the second part. So those judgments were taken in our absentia. So we were not in court. Some were aware that they are going on trial. Some were not even aware these matters going on trial. So most of these defaults come from this whole process where there is no structured resources to deal with trial matters. Because if already we did not defend to summons, as far as I understand with my little knowledge, it's as far as how far will the matter go, and we can still defend it without the resources to take to defend these matters in trial. So most of this default on my side, that's basically what I picked up, that it's either we did not go and defend these matters, no one was in court. Some of them, we did not actually even comply with the interlocutory trial when it was introduced by the judges. We did not comply with some of these matters, then moved into default role. We could also have assess these matters and offered before the trial dates, but due to capacity, sometimes it was just impossible. Hence, we then came up with this project within the team to allocate certain portion of the staff to only deal with matters going on trial, certain portion of the staff going to matters without trial dates, and certain portion of the staff only dealing with interlocutory trial. This is when then we started seeing difference in the Joburg region, where we'll have about 8 matters going to trial, unlike our colleagues in mainland where they will have 400 matters a month. I don't even know how they were coping. But then this is when then we started seeing difference, when we started intervening and putting these controls in place to manage now how we handle trial matters and other offers, and also to ensure that we are fair whether the matter is on trial or not on trial, but we assess all matters, make offers, which I'm just going to add. We had a different way of doing, what's this when we call attorneys to come and settle? Block settlements. In Joburg, we handle block settlement differently. In that process, then, our team will work on a block settlement. They will assess matters. They will have offers that are approved, that mandates are already approved. When the attorney comes in to sign those 50 or 20 or 30 matters once at a go, sometimes you find that some are in trial, some are not. And then we started receiving this little bit of a space gap to breathe, and attorneys also to be flexible to accept what we are giving them, because now we were working on block settling matters that we fully assessed, quality has been checked. The whole risk is controlled, unlike just to take 100 files and go on the road and say you are going to settle matters and assess them with the attorney while the attorney is present. So that actually relieved us, because now we could assess matters 5 months prior to the trial date and settle them, and they are removed on time from the roll. So that's basically how we mitigated that and ensure that we can actually run better.
All right. No, Ms. Mthethwa, thank you very much. So we're going to have a long conversation. Don't worry about matters I haven't asked. I think you have assisted us. I know there is a Sunshine Hospital. We'll deal with it. It will come out in the questioning. The members have got the affidavit. So, Mr. Phillips, thankfully you prepared some slides. You've got more slides. And those slides will assist when we have the conversation. If you need to, really, please feel free. It's that this early portion has to be concise. But if any of the slides that you have are going to be helpful in developing the members' understanding, you can go to that slide that you didn't show. What I'd like to encourage you to do is perhaps to just begin for the members at the point where, I don't know if you got a phone call or whatever, basically somebody says to you, amen, we need to work on something here. So just start us there and then get us into the slides that we said you can show. If there's something that you feel would be helpful in this context and it's not in the slides, you are free to say it, right? So that what we want is for the members to have a full understanding. So over to you. Then we will take a break, and then we'll start with conversation with the members.
Good morning, Chair, committee members, and the public at large. Thank you for the opportunity to give evidence to the committee today. Chair, I think by way of a background, it would be important for me to indicate that I'm a returning soldier to the RAF. This is my second tour at the RAF. I was originally employed between 1997 and 2004. When I left the RAF in 2004, I had been appointed as the first litigation manager at the Johannesburg branch of the RAF, which was then at Marble Towers in Johannesburg. Chair, I spent some time in private practice as an attorney, and in 2011 I was called to the bar as counsel. During my time at the bar, I appeared for both plaintiff and RAF panel attorneys, and Chair, I think 2020 and 2021 were particularly difficult years for the legal sector because of COVID. And obviously, in particular for the Road Accident Fund, the panel of attorneys' mandate had ended in May 2020, and the state attorney model, the scheme of arrangement that is currently in place, had been what was replacing the panel model. Chair, I think it was September or October, I can't remember the exact date, I was interviewed by the Road Accident Fund. Ms. Christina Mthethwa was the hiring manager, and the interview obviously resulted in a successful appointment. I was once again reappointed as the litigation manager at the Johannesburg branch. Ms. Mthethwa was the acting senior manager claims. Chair, since then I have been promoted to the position which I'm currently in, effective the 1st of October 2023, and my current designation is Senior Manager Litigation and Mediation. At a high level, I oversee the scheme of arrangement that exists between the Road Accident Fund and the Office of the Solicitor General, which gives credence to the placement of the state attorneys across the 13 regional offices of the state attorney nationwide. More recently, I'm also coordinating the mediation effort as a result of the Mediation Directive and Protocol that was issued by the then Judge President, now our Deputy Chief Justice Mlambo, on the 22nd of April 2025.
Please continue. The floor is yours.
Okay, thank you, Chair. During my tenure at the Johannesburg branch, what Ms. Mthethwa has indicated with regards the systems that we put in place is certainly correct. I've just counted now, there were 10 state attorneys in the region at the time. Chair, I'm very confident to confirm that by the time I had arrived in the Johannesburg region, the state attorneys were attending to trial work. The majority of the matters were still online. There were a series of directives that were issued by the judiciary in the Gauteng division in particular, relating to particularly the COVID periods and the handling of matters. Obviously, the two divisions of the Gauteng High Court have the largest number of RAF trial matters on the court rolls. And Chair, by the stage that I arrived at the Johannesburg Regional Office, the state attorneys were handling matters, the majority of which were virtual. Chair, if I recall correctly, there was a more fuller return to court round about the beginning of 2022. And the capacity of the state attorneys in the region increased gradually during my tenure as the litigation manager. My responsibility as the litigation manager in the region was an operational responsibility. I had a team of officers within, it was then called the litigation department. It is now called the legal administration department. And I immediately set about putting remediations in place to assist with the management of the trial roles. Initially, Chair, I had an engagement with the Deputy Judge President, Judge Sutherland, to streamline processes. One of the processes that I requested from Judge Sutherland was to issue a notice to the stakeholders at large that required the stakeholders to include the unique identifier or the link number, as we refer to it in the organisation, on all correspondence with the fund, as well as early intervention on the court rolls. Chair, we were finding that the court rolls were coming, and all that was appearing on the court rolls, as they still do from the courts nationwide, is the case number and the reference number, the name of the plaintiff, and obviously the RAF, without any of the RAF information. Chair, Judge Sutherland was very helpful, and he issued a directive to the stakeholders in the Gauteng Local Division, Johannesburg, and that certainly went some way to streamlining the organizational response to trial rolls. We were able to populate the trial rolls so that we could then route to which department the matter was being handled. Chair, we also, one of the remediations I put in place was to separate out a structure in my team where we had a group of officers that were dealing with the trial interlocutory court process. And Chair, just by way of background, trial interlocutory court is basically a trial within a trial. So it'll be an application-based process, and the application is to obtain something from the fund, whether it is to compel service of a discovery affidavit or respond to the RAF 4 form, which is your claim form for general damages. So we isolated a group of officers that would deal with trial interlocutory court process only. We then also restructured to have a group of officers that dealt only with trial matters, bearing in mind, Chair, that there were trial matters in the region that were being handled both by the litigation team and the determination team, which was also one of the departments reporting into Ms. Mthethwa's portfolio. And in addition to that, at that stage, Chair, there was no formal manager for the state attorneys reporting into the region. There was an informal arrangement amongst the state attorneys themselves vis-a-vis the relationship with the then acting regional general manager, that there would be one state attorney that would be responsible for trial allocations when called upon to do so in the region. Remembering, Chair, that at that stage, the strategy of the organization was to settle as many matters as we could. And then, Chair, I think in approximately May 2022, there was a management directive that all matters had to be defended. And Chair, accordingly, I think from that point onwards, we noted.
Sorry, can I ask for simplicity? So, as I understand, the settlement part is basically where the parties meet. That is you as a RAF, and you meet with my attorneys as a claimant. And in the conversation, it's like, come on, man, there's no 15 million here. Okay? And you know it. This is 3 million. And the other one eventually says, yeah, you got a point, and then you settle the matter. Is that the process? I know I'm trivializing, but is when you're saying settlement, can we dispose of this matter between us without going to court? Was that the process?
That's correct, Chair. And I think the spirit of the directives at the time, as they still remain, and the spirit of the recently released mediation protocol and directive is to try and agree on one expert on a particular area of expertise. And the directives at the time, the 2020 and 2021 directives from the judiciary, also wanted us to try and agree on a singular usage of an expert. Bearing in mind, Chair, that when a matter is considered at court, an expert is an opinion that can be accepted or rejected by a judge who's hearing the matter. And in this regard, Chair, I think once there is an expert, obviously the obligation on the organization is to consider the content of the report, whether it's backed up by facts, and are the conclusions logical that an expert would come to in that regard. And Chair, when I arrived in the Johannesburg region, block settlements were very much underway. I refined the process a bit differently so that we could ensure that there was exposure to all the stakeholders in the region. And I think together we were able to put a structure in place, albeit in the Johannesburg region itself, that facilitated the primary goal, which was to settle as many matters as possible for as fair and equitable compensation as possible, but also to attend to those matters on which there was a genuine litigious dispute. Chair, in my new role, new from the 1st of October 2023, I found a model that was already in place, which is the State Attorney, the scheme of arrangement that we have with the Office of the Solicitor General. Chair, the current number of State Attorneys...
Sorry, no. So when I interrupted you, it was because you said there was a directive that all the matters must be defended, right? Can you just take us through that? Because I'm trying to understand, firstly, where did the directive come from? And secondly, what were the reasons given for that, as opposed to settling what you could settle if you felt that the number was the right number anyway?
Chair, I think it goes to what Ms. Mthethwa said earlier. There was very much an organizational understanding that legal costs had to be reduced. And the motivation for the directive, unfortunately, Chair, I haven't been able to find it given the short notice that I had for today's meeting. But I do recall that the directive spoke to the fact that in order to ensure that the interests of the fund are protected, matters need to be defended. And previously, Chair, obviously, the understanding was we are still trying to save legal costs, but you will enter an appearance to defend, and if it becomes necessary to take pleadings further, then you will obviously need to proceed in that regard. And Chair, I think it's also important to note that always we are there to save legal costs. Still, that's a big shift in the organizational structure and the way we look at legal costs generally. Chair, so currently, the State Attorney grouping is...
Sorry, Mr. Phillips, I'm just trying to understand how not settling matters out of court reduces your legal costs. There's court time. I'm assuming depending on the complexity of the matter, you might even need to employ counsel, right? You might even need to employ senior counsel. It seems counterintuitive to me to go to any organization and say, look, if there is a possibility of settling without incurring any further costs, now I'm told in order to save legal costs, go to court. How does that work?
So, Chair, anecdotally, if I may share some stories from my time as a defendant's counsel when I was briefed by the Road Accident Fund panel attorneys. Chair, back in the days of, we had a physical roll call in the Johannesburg High Court. And in the days that I was appearing in the Johannesburg High Court, our Deputy Judge President Mojapelo, there were approximately 100 to 120 RAF matters on the court roll every day. And Judge Mojapelo would have two roll calls. He would have a roll call at 9:30 to establish if there were matters that were ready to proceed to trial at that point. And he would have a second roll call at 11:30, obviously, which was more geared up to the settlement of the matter. So any matters that had settled between the first roll call and the second roll call were then presented on draft order. Chair, on all of those matters, there was counsel. So that's 120 counsel for the plaintiff and 120 counsel for the defendant. That's 240 counsel that were employed almost every day in the Johannesburg High Court. And Chair, 90% of those matters settled. 90% of those matters settled. And there were 240 counsel employed every day. So, Chair, I think just by way of a bit of context, this is where we are looking at the reduction of legal costs. We will defend the action at that stage. And if it becomes necessary to file a plea and take the process further, because we are unable to settle the matter, that's where the process would then continue. And I think, Chair, albeit that it was before my time, I recall seeing letters along those lines that we will enter an appearance to defend, we will pend the litigation process, but if settlement fails, we will then, the process will continue. So there was very much an organizational understanding that there would be a defense of the action, but settlement was always the first prize on a matter.
Okay, so what you're saying is that you indicate an intention to defend, but you still have the settlement negotiations. Okay, no.
That's correct.
It was very important to clarify that because it seemed counterintuitive in my head. Okay, please go ahead.
Chair, currently in my role, I have 105 state attorneys within the scheme of arrangement. We are going to be 109 on the 1st of November. I have 2 state attorneys starting in, one in Makanda, one in Gqeberha, and I have 2 state attorneys starting in Mthethwa. Chair, and let me say at the outset, Chair, when I took up this position in October 2023, I was acutely aware of a capacity problem. There was an organizational moratorium on recruitment because of the fact that the organization, as it still is in an organizational restructuring process, the 189 process, I think is as it's colloquially been referred to. Chair, I found a structure that has 353 positions in it, and there were 108 filled at the time. 300, Honourable Atkinson, 353 positions in the approved structure. 108 were in place at the time. It was approximately a 70% vacancy rate. I was informed, obviously, that I was able to draw, or I was going to be able to draw my needed resources from a pool that was constituted in terms of the organizational restructuring. And Chair, at the time that I joined the team, the voluntary severance package process was just complete because there was a VSP that was offered to a certain level of staff at the Road Accident Fund. Chair, I then set about having meetings with the individual heads of office and the representative from the Office of the Solicitor General. And I think, Chair, we've shared the minutes of those meetings with Scopa. And at the time, I indicated that I was going to be guided by what resources I could get from the OSR pool. Unfortunately, Chair, I was acutely aware of the fact that I needed to populate the structure quickly and with much needed support staff. Now, Chair, just by way of a background, the structure provides for a mimicked version of a law firm. So there are drivers and messengers, there are legal secretaries, and there are paralegals within the structure, the approved structure within which I currently operate. And the interface would be similar to what you would have in a law firm. The difference being that the structure provides for, because there are 13 offices of the state attorney nationally, and obviously there is provisioning for each of the regions. Chair, I then set about, boldly, I think at the time, securing approval to advertise permanent positions, which at that point I was obviously given the indicator that I could look at the pool, but after a period of time, I secured approvals from the then Chief Corporate Support Executive and also the recent acting Chief Corporate Support Executive, who understood that I was desperate to populate my structure. Chair, at the moment, and it's in my presentation, what I've done is I have broken the structure down into approved, current, and provisioned. And Chair, I have successfully placed nationally not all at one time, because recruitment, and I'll touch on that now, Chair, is quite a difficult process with certain of the levels. But I have been able to place drivers, legal secretaries, and paralegals, not all in the same region at the same time, but I have been able to do that over the last 24 months. Chair, in terms of the placement of the state attorneys with the scheme of arrangement that we have with the Office of the Solicitor General, and then obviously the individual offices of the state attorney, a secondment agreement is signed between the Road Accident Fund and the particular head of office of the state attorney. Chair, in terms of the scheme of arrangement, the Office of the State Attorney is very much involved in the interview process for two specific levels of the scheme of arrangement. The first level is the task level 15 placement, which is a magistrate's court state attorney, and the second level is a high court state attorney, which is a task level 16. Chair, in addition to that, I have provided a sample time in my presentation. I used two of the recently appointed state attorneys from time of advertisement to the day that they commenced in the region as a state attorney, and it can be between 9 and 12 months. Chair, in terms of the placement of the support staff, it's a bit of an easier process. I was acutely aware as well, Chair, I wanted there to be a succession plan in place. I wanted to develop a process where a legal secretary could become a paralegal, and they could then eventually move on to become a state attorney. And Chair, I think one of the original concessions that I was able to secure in terms of approvals for advertising these positions was that we would advertise initially internally, and if we were unable to find suitable candidates, we would then proceed to external advertisements for the positions that we might be unable to fill. Chair, I think I'm so incredibly passionate about the state attorney model, and just a few touch points which I'm incredibly proud of at the moment. We have a team of legal secretaries and paralegals, 80% of whom have LLB degrees and they're admitted attorneys. And Chair, I'm also pleased to confirm that on the 1st of November, our first legal secretary is being promoted to a paralegal in the Johannesburg region. Chair, the process of secondment is one in terms of which a secondment agreement is signed, and the state attorneys are obviously employees of the Road Accident Fund. Their salaries are paid by the Road Accident Fund, and they are then seconded to the individual office of the state attorney nationally. Chair, the individual heads of office are, as I indicated, involved in the interview process. The secondment agreement is signed with the individual head of office, and if there are any other administrative tasks that need to be performed, and Chair, I've used the appointment of counsel as an example, there is provision in the memorandum of agreement that we have with the Office of the Solicitor General that if counsel need to be appointed, obviously this is an Office of State Attorney process, and there are two ways in which, for instance, Chair, counsel is appointed through OSA process. That's on a request for quotation. That process is run with the OSA. Alternatively, a deviation process. And Chair, the way in which the process unfolds is an OSA process. There's a briefing committee which sits at the individual OSA, and the selection is then made by that briefing committee. Chair, in terms of the scheme of arrangement, and I think I just want to touch on what Ms. Mthethwa said. Rights of appearance are accorded in terms of two distinct acts. an act dating back to 1995, and then the more recent Legal Practice Act of 2014. Now, I think at the time what Ms. Mthethwa was referring to was the fact that there was a delay in the registration of the state attorneys with the Legal Practice Council. Not that they didn't have rights of appearance, because obviously your rights of appearance are recorded in terms of one of the two acts. But there was very much a delay. I did hear, it wasn't during my time. And Chair, the individual secondment agreement that I have included in the presentation relates to a recent state attorney appointment in Bloemfontein. Chair, obviously, if you are working at the Road Accident Fund, as I am as counsel, I'm on the non-practicing role. But in order for you to appear in court, you would need to be moved to the practicing role. And I think the delay that Ms. Mthethwa was referring to was the fact that there'd been a delay in the registration process of the state attorneys with the LPC.
So the warm bodies were there.
They were there.
They just didn't have the thing that says, okay, you're
You're a
good,
state attorney.
go and stand before or appear on Teams. As it
correct,
was
Chair.
at some
That's
point.
correct, Chair.
Okay, I get it.
And Chair, I think I also addressed it in one of the questions that you had raised. Obviously, in terms of the differentiation between a task level 15 state attorney, which is a Madge Court state attorney, and a task level 16 state attorney, which is a High Court state attorney, rights of appearance are needed by a High Court state attorney if they are to appear in the High Court. In the Magistrates Court, the fact that you're an admitted attorney is sufficient for you to appear in court.
So, Mr. Philip, I was going to say, when I listened to you speak, so the members do have the presentation. You've done a superb job of taking us through, I must tell you.
Thank you, Chair.
I mean, I don't know about the members, but I've been looking at the pages as you speak. You've covered a lot of ground in the presentation. I do want you to just explain something, because I do want us to take a body break. The slides are available. If any of, like I said, you literally can go to any slide. If there's an issue that comes up, you can go to that slide. If there's an issue you feel is pertinent to explain it, you can go to another slide. And so we just at your leisure, just navigate through the presentation. I wanted to understand this block settlement thing. Can you just explain to us how it works? What is the purpose, or what was the purpose? How does it work? Did it help the fund? If so, how did it help the fund? If it doesn't help the fund, so can you just educate us and really treat me like I'm in grade 10 so that I understand?
Thank you, Chair. Chair, I'm going to share my experience from my time as a litigation manager. As I indicated, Chair, and based on discussions that I had with Ms. Mthethwa originally, in the region, each of the regions of the Road Accident Fund has got a dedicated number of attorneys that it's servicing basically in the region. And what you wanted to do, and what we wanted to do in particular, was to ensure that everyone had a bite at the cherry in terms of a block settlement process. So the system that I implemented in the region was we would prioritize trial dates in particular, and then say to attorneys, this is going to be the frame of reference of the block settlement. I wanted, and without wanting to sound like a control freak, I wanted a more controlled space when it came to block settlement process. And what we would do was we would allow each firm, obviously there was a waiting list that we had, and we would allow each firm to have 10 matters at their selection that were compliant claims and that had a trial date. And Chair, I would alternate the assessing team to ensure that no two officers work together for an extended period of time, and also to ensure objectivity in the process. And we would then, there would be a 2-week turnaround time. So you would give us your 10 matters, provided they were compliant, provided they had trial dates. The assessing teams would assess the matters, and we would then present these 10 offers in one online meeting with the relevant attorney. And obviously then the terms of reference of the offers themselves, they had 30 days to accept the offer, etc. And I found, Chair, that it worked wonders to reduce the number of matters that was on the trial roll. And the plaintiff attorneys got very used to the system. We didn't repeat attorneys because I wanted to give as many attorneys as possible until we'd gotten to the end of a cycle. But what we were doing, Chair, was we were prioritizing trial matters so that we could get those matters taken off the court roll. And if matters were settled, obviously there's still the option that the settlement can be taken to settlement court for confirmation of the order. But generally, Chair, that was the reasoning behind block settlement, to reduce the number of matters that were on the trial roll, as well as get early settlements, so that we could take away the need for legal costs at a trial stage.
Right. So in other words, I mean, just give a sense, when a matter from the Road Accident Fund is being heard, I mean, is it like we see on TV with Advocate Dalimpofu and others? It takes all day. Can you just give us a sense? And this is a last question on an educational basis. When a matter is in court and there's counsel, can you just give us a sense of the resourcing that goes into being able to stand before a judge? We're now ready, so let us assume the matter is going to be argued. Just give us a sense of what is required behind counsel, which is a responsibility of the Road Accident Fund. And I'm assuming that sometimes there are cost orders and this kind of thing. The Road Accident Fund ends up paying for the other team as well, in a sense, where costs are awarded. Can you explain that to us as well, how that thing works? Because we need to understand where the saving is. If you can, that's why I'm asking the question.
Chair, I think if I may just come back to my anecdotal story from my time as a trial counsel. And Chair, I think I was blessed in the sense that, you know, when you first start your career at the bar, the first couple of years that you are at the bar, you are establishing yourself. So you have a whole set of years, 2 or 3 years, where your bread and butter is made in motion court. And Chair, I knew that I was going to be a trial practitioner rather than a motion court practitioner when I appeared before Her Ladyship Judge Kathy Satchwell. And it was in my second year, and I drafted the papers, thankfully, for an edictal citation to serve on a doctor in Australia in a medical malpractice matter. And Chair, I was so absolutely terrified of Judge Satchwell, and I think most practitioners will still attest to that. I adore her today, and I think she's one of the greatest legal minds in the country. But as a young advocate, I was absolutely terrified, and I left my chance to go in motion court until about 3:30 that day. And I recall, Chair, it was a winter's day, and I stood absolutely riveted, knowing that I couldn't embarrass myself in front of any of my colleagues. So there was only 2 counsel left. And the way in which motion court works, Chair, is that you wait for seniority, and then you will the more junior you are, the later you go in the day. And I got up, Chair, sweating. It was winter, and I could feel the sweat draining down my robes. And Judge Satchwell had me on my feet for about half an hour, and she was interrogating each and every piece of writing that I'd put in that edictal citation. And every medical term, thankfully, as I said, Chair, I drafted the papers, so I had an intimate knowledge of the papers. And at some point she looked at me and she said, "Mr. Phillips, I'm going to give you your order, but I'm so interested. So this is why we're having this conversation." And Chair, I realized then that I was not going to be great in motion court. Trial work was my forte. Now, Chair, as counsel, you do everything yourself. I didn't have a secretary. I didn't have a paralegal. I only senior counsel, and some of them share secretaries in chambers. The back office work comes from the attorney's firm. And there is generally always a legal secretary who is the support structure around an attorney. And Chair, I think, if I may digress a little bit, I have a team of state attorneys at the moment. I think I have 5 state attorneys who have managed full bench appeals without appointing counsel. They've done it themselves. So what we have done, Chair, and I also give statistics and Chair, I've just used a sample region, which is the Johannesburg region. There are 3 OSA regions that report to the Johannesburg RAF region. That's Kimberley, Bloemfontein, and Johannesburg. And Chair, approximately 50% of the state attorneys who are on secondment are former RAF panel attorneys. So they themselves come with a wealth of experience. And Chair, I was receiving a whole glut of messages from my state attorneys this morning. I think they thought I was going to begin a sentence in the gulag this morning, so they had to wish me well. And one of my state attorneys in Durban said, you know, we never had an opportunity to appear in court because we were always briefing counsel as panelists. And yet I'm very proud to say that today I've been able to complete a full bench appeal. So, Chair, my state attorneys now are in effect appearing counsel. And I think, Chair, that they've run more matters than a lot of counsel that I remember at the bar. Because remember, the way it worked was that you would have 120 matters on the roll, 90% of which settled. And, Chair, my state attorneys are running matters. They are running matters as counsel would. So that's really, Chair, where I think the saving comes in. Because obviously the state attorneys are on a fixed salary. And we have completely removed, and Chair, I'm not going to say that there aren't instances where counsel are needed. There is provision for that in terms of the scheme of arrangement on very complex matters. But Chair, as I said, we have 5 state attorneys. I have a state attorney in the Johannesburg region.
So, Mr. Phillips, the reason for my question is I spoke about recommendations later on, right? You spoke about vacancy rates. So the question I'm asking is that, so even if it's a state attorney, how many warm bodies do whoever is appearing need in order to, so just give the committee a sense of that, because you've said this council is fine, it's now a state attorney, but that state attorney, I don't think they must handle everything themselves, especially with multiple matters. So we just want to understand the support structure that must be in place for an effective defense of the matter, whether it's your guys or, you know.
Chair, in my view, each state attorney should have a legal secretary and a paralegal. There is no provisioning for that in the current structure. There is provisioning for a number of legal secretaries and a number of paralegals. But, Chair, I believe for a state attorney to be fully effective, they would need to have a back office system of, at the very least, 1 legal secretary and then possibly sharing a paralegal between 2 state attorneys.
Last question, stupid question. What's a paralegal? And what does a sort of a secretary do? So can you take Elwas Gaz, my PA, to be a legal secretary? What skill level do you need?
Yeah. Thanks, Chair. Chair, the legal secretary is really, first of all, a diary management system for the state attorney and attending to the drafting of, for instance, the notice of intention to defend, which is colloquially referred to as the NID. So everything that requires process, the scheduling of pre-trial conferences in the High Court, that's in terms of Rule 37.4. And obviously the RAF has a system that requires updating the legal management system, the LMS system, which I reference in my presentation, Chair. So it's a secretarial function, albeit with legal expertise.
It needs to be somebody who's trained in the law.
Correct, Chair.
Okay, that's what and then the paralegal is similarly, it needs to be somebody who's trained in the law, or are they actually a lawyer, the candidate attorney? Just explain that.
So, Chair, in terms of the job requirements for a paralegal, a legal qualification is essential. As I've indicated already, Chair, we are blessed in the sense that the paralegals that we have appointed already, 90% of them are admitted attorneys. So it does require somebody more versed with legalese because there is a more technical support to the state attorney position itself.
So, Mr. Phillips, thank you very much. We're going to take a break, and thank you very much for indulging us. My mind is opened. So thank you very much. When we come back, we'll give an opportunity to the members to have a direct interaction with you. I think, and thank you to you, Ms. Mthethwa, as well. You've really been able to assist us understand the direct claims issue, the full chain, and Mr. Phillips has then taken us a step further on to the conclusion of the matter. So I do think that we are in a good place. Mr. Phillips, because you've got a presentation, as the members speak, like I said, they've got a copy in front of them. Please feel free to go to a part of the presentation and so on. And then any other documents, because we kind of also weren't aware that there are documents coming in, they're voluminous. Those will be sent to the members. So let's just keep everything at the level of conversation. But you can refer to the document, and then the document will be supplied to the members for our later conversation. And so thank you very much to both of you. You've been incredibly helpful. We're going to take a 15-minute break, and then when we come back, the only thing I'll be doing is time management of the members as they have a conversation with you. Thank you so much. Members, it's 11:20. We'll come back at 11:35. And I won't forget you, Honorable Isaac. Don't worry. I won't skip you. I won't skip you. Thank you. Honorable members, thank you.
Thank you for that question, Honourable Kubeka. And it's an interesting question because we had lots of litigation when I was at the fund in my first tenure. I think there was an article that was written by Prof. Kloppers detailing the escalating costs of the panel that was published in Derabus in 2019. And I think we became acutely aware towards the end of 2002 that panel costs were escalating, and that we needed to focus more on early settlements. But I recall that discussion around settling matters en masse started in approximately 2002 because costs were spiraling.
Can I add something, Honourable? I think if I hear you correctly, you just want to understand why was it litigation centered, right? In my opinion, RAF is a litigious environment. Because of this fault-based system, you need to prove the fault before compensation. Now, that's difficult for a layman to go through that process. And when you're looking at it that way, hence we, in originations, we became more of agents of the fund to assist the victim in claiming. That just shows that it's not an easy process. Even on the current process that is there, it's very difficult for a layman to understand the issues of, unless even myself, I didn't understand it, even though I might have qualifications, but the language of how this act is interpreted into operations, it's very complex for a normal person, even if you can have a doctorate. It's not easy to interpret and claim for yourself if you do not get the assistance that's directly in assisting you. For instance, now, this new form, you need to prove liability to the fund. How does a person that is sitting somewhere in Guyana going to understand how do I prove liability of the fund? It's very complex. So now the issue of being litigious-centered, I think it comes from that part, that you need to prove liability, it's fault-based, and if you can't, you won't succeed with claiming in the fund. The form itself, to complete it, it's complicated unless you're assisted. It's not easy that I would pull through the form online, complete it and submit it. There will be a lot of issues that are mentioned underneath. You need to bring this, you need to bring this. If you don't, then you need to do this. There is issues of summons, there is all those things. A normal person will not do it without a structured guidance or a process that a fund creates to simplify it for a normal person to do it. That will be my opinion, that the reason it was litigation-centered was because of that fact.
No, I think that makes sense, because we now know and we understand that that whole list of items that you need to bring in to try and quantify your injuries, to try and have your specialists, to try and have your actuaries. The lawyers that basically now come in to claiming these large amounts from RAF, basically crippling RAF, have got that whole process streamlined. That if you need an actuary, they're here. If you need a maxillofacial surgeon, they're here. If you need a whatever, spinal surgeon, they've got that whole process streamlined. Now, I think on the side of RAF, outside of the direct claims that were there, this is now for Mr. Phillips, would the lawyers at RAF that you've been dealing with have a similar structure to the structure that I'm talking about now, with specialists and psychologists and all of that? Do you have the same structure on your end as lawyers for RAF?
Thank you, Honourable Kubeka. obviously there is a streamlining of work process in the organization, and there is a medical management department, and the provision for the appointment of experts is a combination of the expertise from the medical management department and then obviously the operations space itself. Where the state attorneys become involved is obviously when they're drafting and serving notices in terms of which the notification of the expert appointments is given, and then obviously when the medico-legal reports are prepared and they are then dispatched. So that's where the operations space and the medical management space attend to the expert appointments and the nature of which experts are required, and then the state attorney group attend to the legal side of it in terms of notices, etc.
Just a quick one, and this one will be quick. With the claims that were being handled directly, what were the timelines, more or less? I'm trying to quantify that versus what kind of a timeline would be achieved when using a lawyer. What was the difference in timelines, possibly, when you guys were doing it with the teams that you had in place?
You mean in terms of lodgement or in terms of settlement?
From the time you lodged to the cases being settled, the cases basically that were being submitted directly to RAF by the teams that you were handling.
Okay.
If you were to compare that to what a lawyer would do if a claimant went via a lawyer, which process would have been quicker?
With regards to direct claims, because of we did not have a process that goes through this litigation process, the process will be shorter, of course, because now you are not waiting for trials or there is an attorney involved. It's just the direct claims with just us representing the claimants with a department that is responsible to process only direct claims. They're not involved with claims that are represented. So there were separate departments in the region. There's a department that only processes direct claims, and there is a department that only processes represented claims. So our timelines was actually short because one of the issues that we were also avoiding is to reach that period where prescription needs to be interrupted. So we will try and avoid that. So in order for us to avoid it, we needed to ensure that there is strict monitoring. Actually, if the file has everything in it, it will be processed within a space of a year. That's if everything is that then it though excludes the settlement of an undertaking certificate, because that will be issued within a month or two, as long as it's got the necessary information, because that portion did not need all experts reports and end. It will just be the matter of that SMR completed by the doctor that confirms the seriousness of injuries, and that portion is settled as soon as the file goes to mainline, which will be a month or two. Actually, not even a month or two. You could get an undertaking within even 2 weeks as part of settlement from the time you lodge the claim. But the actual total claim, it wouldn't be settled. Mainly they will wait for the MMI to be reached, and they will start settling the claim. So it was not really taking very, very long, because within a year the MMI is reached. Thereafter the claim can be settled, because we know exactly the extent of injuries that are permanent. So basically it was driven by that. But other than that, it is faster to settle the claim directly, because even when it comes to appointment of experts, when a claim is direct claim, one of the issues that the organization was trying to mitigate will be the issue of unnecessary experts reports. For instance, if the claim is represented, you find that once liability is confirmed, there will be not on the current structure, of course, before. Now it's different. The attorney will then go and get the different experts report that they think will support this claim for it to be settled. And it's one of the issues actually the CO tried to mitigate, to say they go for shopping to get all these experts. and it's one of the issues that direct claim tried and managed, because now we had a panel of experts that came in just after the direct claim was established. They then appointed a panel of experts, medical experts. And then as a direct claim will then know which experts report the team needs, which is direct claims that's handling the claim. Once they know which expert, they will only go for that expert report to support the quantum. They won't just go for all experts report. And sometimes you don't even need an educational psychologist. Sometimes you would need a neurosurgeon's report, because the hospital file already has that information. You don't want to prove it because the person has already reached the MMI. And secondly, other than that, the record itself is supporting the medical part of the seriousness of injury. Maybe the only thing they need might be actuarial report just to quantify, if they cannot quantify it in terms of loss of earnings. But then other than that, the process was not lengthy at all, and it cut out all these legal costs that were not necessary in terms of experts report, and only focus to what is necessary. So in terms of speedily, I won't really say this is the time frame, but really the time was shortened based on the actual process.
Okay, so Ms. Mthethwa, try and keep your answers concise. I feel sorry for Honorable Kubeka here, so I'll indulge you with two more and then I move on.
Thanks, Chair. I think Chair, yesterday we wanted to ask who from the Road Accident Fund was supposed to give RAF lawyers their brief and mandate. Please.
Thank you, Honourable Kubeka. The instruction to the state attorneys that attend to the RF matters comes from the operations space. So there is a litigation management system, colloquially known as LMS, and the origination of the instruction comes from whichever department in the operations space is requiring the legal service from the state attorney.
I think the reason we were trying to ask that was to try and find out or figure out why so much work was not being done in that space, or why the lawyers representing RAF were not basically given mandates to go and either defend or do whatever in court. So we're trying to understand what was the process there. Why were there shortcomings there? Because a lot of money was wasted with lawyers not defending and so on. So we're trying to find out who was the person that was responsible for that at RAF, and maybe it was different people. So could you highlight to us who that person or those people were?
So in as I said earlier, in terms of where the instruction comes from, it could be an instruction on a notice of motion, for instance, on an undertaking claim. That would come from the medical management department. It could be an instruction that resulted from a former panel file that is now going to trial, and the state attorney needs to attend to a trial on a matter. Or it could be an initial instruction where a summons has been received by the summons unit in a particular region, and the matter is then allocated from the beginning to a state attorney on LMS. And the theory is that the state attorney is then expected to walk with that file until completion of the process itself. So there are multiple areas within the organization where the instruction could come from in terms of the allocation of work to a state attorney.
Last one.
I wouldn't want to ask another question, Chair. I was going to seek your assistance here. I think you know what I'm trying to ask here.
No, just say what you want to, so that I don't reach the wrong conclusion.
Chair, at the Road Accident Fund, there must be a team or an office or someone who can basically be held responsible.
Oh yeah, I get you.
Yeah.
So in other words, so what Honorable Kubeka is asking is that there's got to be someone with overall responsibility for all litigation matters. From the point it becomes clear that this matter is going to be litigated all the way through, but because what we're battling to understand as the committee is how does it happen that there is a court date and the matter is supposed to be defended on that day and there's no one, right? or that the Road Accident Fund is not ready to defend the matter, and all sorts of other problems. So that's why he's asking, so how do we end up here where matters aren't defended? The RAF asked for a rescission on a matter where they failed to appear, and there's been a default judgment given, and now the RAF is coming back to say, please set aside that decision we did not defend. Who's that person? Or why isn't there that person?
Thank you, Chair. I think it's important, by way of a background, to acknowledge that the RAF has a quasi-judicial determination of a claim until such point as a summons has been received. Once the summons is received, the litigation process commences, and then obviously the final arbiter of a claim is a judge. And Chair, I think there seems to be a misnomer that a default judgment equates to a lack of entitlement on a claim. Chair, when a judge is...
No, that's not where we're going. The question is very specific. Let me leave the default judgments out.
Sure.
Why are some matters undefended? Why isn't there a lawyer there?
Chair, I think the simple answer is capacity. Capacity from both the operations space and from the state attorney grouping. I think that's the simple answer, Chair.
Who's responsible for capacitating the Road Accident Fund in that respect?
Well, Chair, I'm responsible for capacitating my area, and then depending on, as I indicated, whichever area the instruction comes from, the capacitation remains, if it's from the medical management department or the claims department, capacitation relates to that particular space.
So, Mr. Phillips, I would think that there is a senior legal officer, there is an interaction at a group level, let me say group level, because the RAF has got regional, so it looks federalized to me, the way that you're explaining it, right? There's got to be somebody in Manlin, I think the head office is in Manlin, who can produce a dashboard, who's got a dashboard, who's given a report every month to say, this is how many matters we have in the Eastern Cape, Western Cape, etc., etc. This is how many are going to trial, and this is where we've got an attorney to appear or not. Is there nobody who does that there?
So, Chair, when instructions are given to the state attorneys via the litigation management system, an audit can be drawn from that system, but Chair, the system is not necessarily 100% fit for purpose. In fact, as an organization, we are going to be going to the marketplace shortly for an end-to-end litigation management system to provide the kind of reports that, Chair, you're referring to. In private practice, there's something like ghost practice, which...
Okay, that doesn't help me, Mr. Phillips, at all, okay? The question I'm asking, and I'll come to you, Ms. Mthethwa, the question I'm asking, is there an executive at the Road Accident Fund whose job it is to make sure that the rest of the system in the organization works as it should in as far as management of cases? That executive has the discussion at the executive committee about resourcing, about caseload, about the court roll, how many matters per day. That's the question. There's a system we can discuss later. Is there a person you report to who does that job?
Yes, Chair. I report to the Chief Governance Officer, and we provide statistics to the Chief Governance Officer on court process and matters on court rolls, etc.
Okay, so have you had a discussion about resourcing then? Is it a resourcing matter? Is it a systems matter where it appears that people have, attorneys have two matters pending at the same time in the same courtroom? And so why does that happen? Whose responsibility is it to make sure that sort of thing does not happen?
Yes, Chair. And in fact, obviously, it goes a lot to a discussion around increasing capacity. Chair, the solution is not just to increase state attorney capacity. What we also need to do is increase capacity in the operations space so that the number of matters that can be settled without litigious disputes can be greatly reduced. So, yes, certainly, Chair, there is a capacity issue that is discussed regularly, so that we can increase capacity and then also increase what's on the approved structure.
So let me ask this. So when an attorney from the RAF is supposed to appear and they're not there, what typically happens? What does the court say?
Chair, you'll have a situation where there could be an instruction, multiple instructions going to a state attorney for multiple matters on one day. And obviously in certain of the divisions, it's not appropriate to appear on more than one matter on a day. I'm thinking of the Gauteng division in Pretoria in particular. And Chair, what the state attorney would do is indicate to the client, the RAF, that they are not able to appear on all of those matters in the event that they are not settled. And indicate to the operation space that you will need to make a different plan when it comes to as a state attorney, not being able to appear on multiple matters in the event that the matter is not settled. And Chair, obviously this is a capacity issue that I've referenced already, because if there were state attorneys on all of the matters, this kind of thing wouldn't occur.
So why isn't there somebody who says we're going to have a problem on the 8th of November, where Mr. Kubeka here is going to have 3 matters on the same day? Why isn't there somebody who foresees that? And I will come back to what the court says, because it actually is important for our purposes.
Sure. Chair, and I think the way the system is configured at the moment, we don't necessarily have a globular view, because remember, instructions are being fed in from many regions into the high volume litigation region of Gauteng. So there are other regional offices that have matters proceeding in Gauteng. And Chair, I think this is really where we're going in terms of the new system that we are looking for.
No, sure, we'll get there. What I need to understand on behalf of the committee, why, I'm not sure which, I don't know if it's Johannesburg or Pretoria, where you're not allowed to have more than one matter on the same day. So we know this. And I do understand that part of the reason was actually you guys, because of this problem, where you wouldn't appear in the next room because you are busy next door. The question I'm asking, if I'm the attorney, I know I've got 3 matters. Why do I not know 2 to 3 weeks in advance so that we can manage it through the clerk of the court, that the matter is removed from the roll? Because I really do want to get, because I've read many judgments of the Road Accident Fund where you guys are not there. The court eventually gets very upset with you, and they award costs against you. And that's what we're concerned with as a committee. So let's not get around the issue, because it's important for the cost discussion we're going to have. So 2 questions. Why is it not possible to withdraw the matter or postpone it or whatever the case might be? Number 2, when you guys don't show up in court, typically what do the courts say? Do they throw their hands in the air and say, oh, well, they're not here, we'll have to find another date, sorry for you, plaintiff? Is that what happens?
No, Chair, that's not what happens. In practice, there are often late allocations from the operations space. And I think in particular to do with former panel matters that were handled by the former panel attorneys. So there is an element of matters where the allocation is done in a very close proximity to the trial date. Generally, Chair, the way the system works is a combination. In the region, we have 2 litigation managers that oversee the allocations of trial roles. So say, for instance, in the Johannesburg region, a trial roll is released a week in advance of the trial date, the default judgment court roll. And the management team in the region will then allocate all of the matters on the trial roll to state attorneys. So each matter that appears on the default court judgment trial roll has a state attorney allocated to it. Whether the state attorney is the same state attorney that was given the matter on LMS, it's determined by the fact that, for instance, in the Johannesburg region, there's a structural grouping. So you have one group of state attorneys that attend default court, and you have one group of state attorneys that are currently attending mediation. And obviously the structure changes depending on what the results are and the success of each of the groups. So in essence, Chair, in Johannesburg, the default judgment court roll is allocated to state attorneys. the structuring of the default judgment court role in Joburg is you generally have 2 judges who handle a default role from Tuesday to Friday. And there's 30 odd matters on each of the default roles, and that role has got to be completed by Friday. So there's always a state attorney that is allocated on the matter. And Chair, it's discretionary on the part of a judge if they allow a state attorney to make submissions on a matter which is on the default role.
No, Mr. Phillips, I must tell you, and I'm going to go into my computer and fetch the judgments. This is what happens. There'll be a couple of things. Sometimes there's nobody in the court to defend the matter. Sometimes there is somebody to defend the matter. They say, I don't have instructions. Genuinely, I'm not lying. I can fetch the judgment. What Honorable Kubeka wants to know is why all of this chaos. I hear all of that. The court processes are not a mystery. The courts are creatures of habit, as you would know, all the way down to the font size. Okay. What we want to understand is that despite all the predictability of the process, nobody is able to identify that we don't have enough lawyers. And on that day when the matter sits, there will be nobody. Or the person who's going to appear there is a person with no instructions. Because what I have seen is that the court then will either make the award plus costs. And then later you guys come and apply for a rescission because there was nobody there. It happens, right? And I've seen judgments where the court is now relitigating, and in the application, the counsel for the road accident, wherever they're from, they get key facts wrong. They think the meeting was virtual. The judge says it wasn't virtual. It was in my courtroom. I was sitting here. I presided over the matter. So clearly the person is at sea. That's what we're trying to understand. So you've mentioned capacity. What you're not helping us with is a straight answer to say, we don't have a system and there's nobody with a performance matrix on this to make sure that it doesn't happen. Would that conclusion be correct?
Chair, I think it's a combination of everything. It's a combination of the capacity issues. It's a combination of systems which don't necessarily speak to each other in terms of the litigation management process. And that's really what we are aiming to correct, is that we need to have that sustainability in terms of the performance matrix and what resources are available on a specific day to attend to the number of matters that are enrolled for a specific day.
So thank you. So Honorable Gupek, I'll allow you one last question. Here's a problem. The Road Accident Fund spends over 40 billion. So back when Ms. Mthethwa was telling us about the good old days, the Road Accident Fund used to spend about between 41 and 44 billion a year on resolving over 250,000 matters. It spends the same amount of money now on 60-something odd thousand matters. It does. We've got the numbers. It does. The costs have gone up 70%. It's gone, I think it's quadrupled the average value per claim. It's in the annual report. The members went through it. What we need you to help us, because this is what appears to be the case, as one of the reasons. When nobody is in court to defend the Road Accident Fund against an inflated claim, the judge is left with no option but to award. I saw a case where the person was said to have suffered brain damage, but they were doing really well at FET College. It's a judgment in the Gauteng, in Pretoria. And the judge complains about this, and the judge says there was nobody. The lawyer there said that they don't have instructions. And so the person walks away with what appears to be an inflated claim. That's our stress, Mr. Phillips, and I don't think you are assisting us in terms of candor.
And Chair, I think also a judge, and I know this is what judges do. Some judges indicate that don't come to court without instructions. Don't come unless you can make representations on the claim. It's not going to be prudent for you to come and say, I don't have instructions. That's not an instruction. And I think, Chair, that certainly does also result in a lot of the judgments which are presented. Because state attorneys are told on a regular basis at court, if you don't have instructions, don't appear on this matter. It doesn't make sense because you don't know what you're going to be telling a judge in process. I know that there's certainly that in the Pretoria High Court, Chair, that's the narrative that we are getting from court.
Right. Honorable Kubeka, last one.
No,
We've
fine,
overshot
Chair.
our time.
It's not even a question, Chair. I think we must just agree that this idea of having someone at the Road Accident Fund who is basically responsible for lawyers that represent the Road Accident Fund is non-existent. There is no person basically that the lawyers that represent RAF that sits there with a dashboard or with a matrix to say, okay, on the 18th, these are the lawyers that we have going to court. These are the instructions that they have. This is the desired result. So I think we must just agree that there is no person like that. And Mr. Phillips, we're not trying to fight you here. We're just trying to find the answer to this question, because I think you earlier said the chief governance officer. If we were to bring in the chief governance officer here, the likelihood is they too would not know about what is going on in half of the region, because you say you've got regions all over the country that basically speak to Pretoria, where the head office is. But there's no one who's sitting in Pretoria who's saying, okay, this is what's going on here, 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 here. There's no one in the region who says, okay, in this region, these are the things that we're dealing with. These are the matters that we're dealing with in court. These are the lawyers that we have. These are the capacity issues that we have. These are the shortfalls that we have. So there's basically no formal system like that. I think we are in agreement here. Thank you, Chair.
Do you want to say anything?
Nothing further.
Okay, thank you. Honorable Atkinson.
Thank you very much, Chair, and thank you to Ms. Mthethwa and Mr. Phillips for coming to speak to us today. I'm just going to start with Ms. Mthethwa. You mentioned to us about the direct claims process that was in operation when you started out, and how you had people at hospital to deal directly with potential clients of the Road Accident Fund there. Because they weren't represented by attorneys, what would have happened if there was a problem with their claim? How many of those claims actually prescribed? Because there was no attorney to go and get a court date or something. So what I'm trying to ask was, how efficient was that process actually?
Thank you. I almost, let's say, honorable. Thank you. The issue of prescription within direct claim, as far out, I will speak on it based on my position as an originations manager.
Yeah.
So what happens is when a client lodges a claim, once the claim is lodged, that prescription falls out. So if your accident was on the 20th of February 2 years ago and it was a hit and run, you need to lodge it on the 19th of February, within that space of 2 years, to avoid prescription. Then once the claim is in, there is a monitoring, as far as I remember, within direct claim. So we had our data analyst within the region. That person was responsible then to pull through the data and communicate it, so that the team responsible to process the claim, they know when that a 5-year period looms and work on those files. So I wouldn't know then, because the team was managed by another department. I wouldn't know if maybe they had faced, I'm not very clear how that was dealt with, but from our side in originations, we ensure that we lodge those claims before they prescribe. If it has prescribed, then we do not lodge it. We inform the client that unfortunately the claim is prescribed. There is nothing we can do. But once the claim is in, then there were those metrics that were in place from the data analyst to communicate those figures and dates, so that there is tracking that's in place.
Thank you. I think you're probably aware that there was a move within the Road Accident Fund when they changed the accounting procedures and when they changed the RAF1 form and everything to try and reduce the amount of claims. Well, that was the effect of it, and that, I think, was the intention of doing all that. And obviously that instruction to you not to go out and seek direct claims and all that thing. So in essence, what you're telling us about really was what we've been hearing for the last 2 weeks is about the fact that there was a push within the Road Accident Fund to reduce the amount of claims that were processed and actually not to highlight direct claims at all. So, in fact, we were told, I think, only 3% of all claims at the moment are direct claims with the Road Accident Fund. So it's very interesting because what you've told us, in essence, actually does means that everything we've been told is true, basically. So, I mean, you've strengthened the evidence. Thank you very much. I just wanted to ask, in your own personal circumstances, you were employed in 2014, and then you said you were dismissed in 2023. What led to your dismissal, as a matter of interest?
My dismissal was led by the issues of Sunshine Hospital. Yeah.
Okay, now, we had the executives here from Sunshine Hospital, and they said that there was allegations of misconduct of certain people with Road Accident Fund and Sunshine Hospital. And apparently an investigation was carried out by the Road Accident Fund, and no misconduct was ever found. Yet I see somewhere here that a number of people were dismissed and suspended. No doubt you're one of the victims of that.
Correct.
How were they able to dismiss you then if they weren't able to find any evidence of wrongdoing, basically? I mean, how did they legally base your dismissal? That's what I'm trying to ask.
Not to dwell deeper into the merits, there were constructed allegations based on our KPA during the time of direct claims. For instance, some of the questions, we were attending the accident scene and assist the victims. When we investigated, then they will say, why did I do that? The allegations will be around your own KPA, but because of the mandate, it was very clear that these people must go for whatever reason. Yeah. That's basically that they will go and say, for instance, the driver, the mobile officer, they will say you use the company car to go to Sunshine and lodge the claim. But that was the business of the day. It was the modus operandi. Then how then suddenly it becomes a misconduct. So it was those issues. And just for extra clarity, Sunshine was not the only hospital lodging claiming from the RAF, nor were their claim guided by the incorporation cooperation agreement that they had, called it an MOU. No, it wasn't. All hospital claims the same. We lost claims from all hospitals. So they used an RAF2 form, which is a legislative document or a regulated document that they can use to claim just like any other covered under Section 17 of the Act. So there was really nothing irregular. Even in the report of FID, there was no findings at all. Even SIU did go to our offices to investigate, and they come out. We saw that in their report there is no mention of such as well, and they did go to the ground to investigate. So yeah, we don't know.
Thanks very much for that. Why, in a sense, was Sunshine Hospital sort of singled out? I mean, there was, I think it was here in the affidavit where Road Accident Fund refused to pay any further claims and led to the hospital's closure because it was 300 million rand owed to them. And it seems to be based on no evidence at all, basically, on allegations, but no evidence. So was there an instruction given out? I mean, that might have happened after you left. I don't, because I see you left in 2023, but was there an instruction that went out that Sunshine Hospital mustn't be paid anymore?
In our meetings, yes, there was that in communication, just the same as the one to close direct claims. So not necessarily a written instruction. There was an instruction because the claims were not paid. The matter went to court. Sunshine won against the fund. Following that, an investigation was commenced that if then they are not guilty, that means it's the staff. So either way, somebody had to explain the issues of Sunshine, and there is actually a deeper background than what has been submitted, because of maybe what we picked up on our side. The reason Sunshine claim, for instance, will be suspicious was because Sunshine claim, I don't know how they mitigated the risk, but what they will do, they will submit one file with all a multidisciplinary team's invoices in one file, while in Netcare or Mediclinic, for instance, the hospital will bring its own bill, different link number. The doctors, each doctor that was involved will bring their own bill with its own link number. So you'll never link this claim to quantify how much was the total invoice for a particular victim. But with Sunshine, we'll say, okay, fine, it's 500,000, but in that 500,000, there is a breakdown of the hospital, the doctor, the anesthetist, the surgeon, and in one invoice. So Sunshine dealt with it differently than other hospitals, and you could never link the total of other hospitals than how you would with Sunshine Hospital. So we really don't know what drove the decision, whether really it was dwelled deeper into the actual outcome of the investigation. We don't know.
All right. Well, thank you very much. Thanks for your answers. And turning to Mr. Phillips, I believe the gentleman sitting next to you used to manage the panel of attorneys before it was, is that right? Before it was disbanded?
Thank you, Honourable Atkinson. Yes, he was in the panel management department.
Okay. Are we allowed to ask the gentleman sitting next to him any questions?
We need to switch off one of the mics so that I can be audible. Okay, so I've just been consulting. So he's not sworn in. So, sorry, Ms. Ibrahim?
Chair, the official was here when we recited the rules and explained the process. I can just do a very quick swearing in of just raising the right hand. It won't be necessary to go through the whole process. There's no legal requirement to be sworn in when you appear before a committee, but our own terms of reference did indicate that witnesses should be sworn in.
All right, so please do the honors. You're happy to assist us, right? Okay, we don't want to we don't want to push you into the pool when you're not ready to swim. Okay.
Thank you, sir. If you can please just state your full name for the record.
My name is Nyeko Baloy.
Okay, thank you, Mr. Baloy. Is your preference to take an oath or to do the affirmation?
I can take an oath.
Okay. If you can please raise your right hand and repeat after me. I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
You're now duly sworn in, Mr. Baloy. Thank you.
All right, thank you. Honourable Atkinson, proceed.
Very much. Thanks, Mr. Badoy. Am I correct in saying that you were the manager of the panel of attorneys before they were disbanded?
Through you, Chair. So I was the manager of the panel of attorneys, as well as Ignatius Briel, who's currently the director at the LPC. So we played a dual function, I suppose. We were managing quite a number of panels. It wasn't just the panel of attorneys. There was a panel of medical experts. There was a panel of assessors. There was a panel of actuaries.
And in your opinion, was that all reasonably efficiently run, and was it kind of fit for purpose in essence?
Chair, I'd struggle to answer that question, but from my opinion, it was very well run. I joined in 2019. Obviously, we had a lockdown after that. Then I was moved to Menlyn to be the acting senior manager litigation and claims in around 2020 November. But during that time, it was well run.
Then when the decision was made to do away with the panel of attorneys, was there any communication to you or any attempt to include you in that decision as to what should replace it, basically? And were you given any indication as to what the next step would be after that, basically?
Yes, I was part of the process. I wrote most of the letters that went out to the panel of attorneys. I mean, there was structured thinking around why that needed to happen. So yes, there was a logical trail as to why we did what we did at the Road Accident Fund at that time.
Okay, because the one thing that seems to be coming through quite strongly is that, I mean, you know, Mr. Phillips has been dealing with people from the state attorneys, but there really are just not enough people, basically, because I mean the amount of claims that have come through, and particularly if we look back at the numbers of 2020, where I think 320,000 claims have been processed in this last year, was down at about 72,000. So I mean it's literally a fifth now of what it was, and I know that there was a definite push to reduce the amount of claims going through for a number of reasons, and because of the accounting standards and the board notice and RAF 1 form and various other things. But the issue is, if it was thought through, how could they have left such a hole where there just really were not enough people to be able to litigate on your behalf or deal with matters correctly on your behalf?
Yeah, Chair, the fact of the matter is that in as much as there was a hole, as we say, but that was caused because of the numbers. But number one, we need to get to the genesis of it. Panel attorneys refused to hand over files. They refused to go off record. They were actually pitching up in court and sitting and watching default judgments be taken. That's why if you look at Mr. Phillips's numbers, you'll see that during the period of between 2020 to around 2022, how high the litigation costs or the legal costs were. That was on account of panel attorneys refusing to return files. And that's a fact of it.
Did they have any legal basis to do that?
They didn't, but I mean, there's a Mabunda and a million others judgment where you'd see that they were fighting not to return files because the logical basis was, I suppose, that they were losing business. And we wanted to stop the bleeding of money that was being paid to panel attorneys who were sending advocates to court and not appearing in person.
Okay, yet the evidence that we're getting is that the cost per settlement is now 3 times what it was back in 2020, 2021. So I think an average settlement from what I remember was about 120,000, and now it's up at about 340, 350. And that includes obviously costs and various other things. Sorry, the costs, not necessarily the settlements, but the costs.
Chair, I mean, when you consider the inflation of costs or inflated settlements, you need to consider the fact that there's inflation to be contended with. More professionals are obviously getting into accidents, and the fact that children are also claiming. Inflated costs start at the genesis of claims. They're not at the tail end. At the very inception of a matter, it's already been quantified, even if it's a thumbsuck by a plaintiff attorney. Even Mr. Nell can come and tell you, most of the summonses that we receive are naked files. There are no expert reports in them. There's nothing. That is why when we do the mediation drive, as Mr. Phillips stated, you will find that when a matter needs to be mediated, it's not mediatable because it's naked.
Do you have the capacity at the moment to mediate within the RAF? I mean, do you have if a lawyer wants to come in and mediate a claim, because I know that apparently the courts have now required more mediation to take place. Do you have capacity to mediate? So if lawyers came to you to mediate, would you be able to do that?
Sorry, can I say so? Just so you know, so the sound is better for the streaming if when one person is speaking, the other one switches off the mic. So let's do that tennis, that table tennis, and then the sound will be good.
Can you please repeat your question again?
You spoke about mediation, and you mentioned getting naked files. I think the judges have actually have asked for more mediation. What I'm asking is, as the RAF is set up at the moment, are you able to mediate with lawyers? I mean, do you have the capacity to mediate with people?
So Mr. Phillips and I sat in the Mediation Implementation Committee, which was chaired by Judge Davis. Subsequently, we received the mediation directive on the 22nd of April. We were charged by our CEO to establish a mediation administration committee, which we did. As part of that committee, when we receive mediation notices, we're meant to make a determination of whether or not we accept or reject mediation. We do that. In our first report back to the judiciary, we informed them that of the matters that we received, around, I think 90% of them, I don't have the numbers, Chair, but I can provide them. More than 90% of those matters were matters without trial dates. And that was precisely what the mediation directive sought to extinguish, the pressure on the judges in court. And you would find that also when we do accept mediation, plaintiff attorneys are simply silent. They don't come back to us with a mediation date. They're quiet. of the few mediations that we have done, we've done around 39. Matters have been settled due to the exertion of pressure because of mediation outside of it. But finding plaintiff attorneys that genuinely want to mediate is a thing that is few and far between, and that's a fact of the matter, Chair.
The other question I wanted to ask...
Last one, Honourable Atkins.
All right, then let me ask Mr. Phillips, or else I'm going to miss out on asking Mr. Phillips a question now. It was very interesting because you mentioned the fact that this is your second tour of duty at the Road Accident Fund. So your first tour of duty was, I think, 97 to 2004. Yeah. So in an earlier iteration of the Road Accident Fund, it appeared that it was considered to be something of an error if something ended up going to court. Is that generally most claims were actually settled at the fund itself. So people came and negotiated, and there was very little that actually did go to court. So in essence, it really worked on settlement, which in a sense would have, to my mind, would have saved you a lot of legal costs of matters not going to courts, no default judgments and things like that. Do you not think the way it was run then was actually more efficient, was basically cost you less from a legal point of view? And probably you're able to obviously get through a lot more claims than you can at the moment. Was that not a superior system to what you've got at the moment?
Thank you for the question, Honourable Atkinson. The answer is absolutely yes. I can share my experiences. I was a claims handler to start off with at the fund. And I do recall that if you received a summons, you had to go and explain to your manager. It was either that there was a genuine litigious dispute on the matter, or the summons was served to interrupt prescription. Back in the days of claims handling, when I was a claims handler, a summons was a swear word, in a way. But granted, the capacity was each claims handler had an assistant, and the volume of work was not as high as it is today. When I was a claims handler, I think I had approximately 400 files. And you are now looking at file counts with claims handlers in excess of 2,000 and 3,000 matters. So I think the system itself is comparable in one extent, and in another way, absolutely, the system was geared up towards settling matters as quickly and as expeditiously as possible.
Yeah, no, thanks for that. And I think the issue does come back to resources, as you mentioned. And you know, when you came in and you spoke about the fact that I think there were was it 370 posts and only 104 people at the point you made earlier.
It's 353 posts and 108 were filled at the time.
So I think this really does take us back to the point that when the decision was made to get rid of the legal panel, that a properly set up system with the right amount of people was really not in place. I mean, in essence, you had to come in and try and save the day in any way that you could. And in essence, there's still parts. When I look at Pretoria, someone sent me a message today that there are apparently 20 default judgments in the Pretoria High Court on the 27th of October. So it's obviously still an issue with default judgments. There are not enough people to deal with things. So it is actually a resource issue. And I think it's probably fair to say that at the point they got rid of the panel of attorneys, they might have had an idea of where they wanted to go, but there was a big ravine between where it was and where you needed to get to. And in many respects, the RAF had kind of fallen into that ravine, unfortunately.
Can I come
Oh, yeah,
in,
of course. Yeah.
Yeah, Chair, obviously you'll find 27 default judgments in the Pretoria High Court. I mean, that's the country's biggest litigator in terms of courts. And this is where most plaintiff attorneys issue out their summonses, because they want to put not only the RAF at risk or under pressure, but the judiciary too. That's why even Judge Mlambo came and said that there's a resourcing issue with the judiciary. So it's not a matter of us not doing the work. It's a matter of where the pressure is. In say, Cape Town, you won't find as many default judgments, not because work is necessarily being done properly there, but it's a function of the system. Where do plaintiff attorneys go? And also, Chair, just to get back to what Honorable Kubeka had said, it's not correct to say that litigation is not managed at the RAF. At each and every region, Chair, there's a manager, litigation and claims, there's a senior manager litigation and claims at every region. Summonses are on LMS, litigation management system. Trials are on the trial application. These things are reported to both EXCO and the board. So it's not correct to say it's not managed. It's being managed, and here we are, we're managing it.
Right, thank you. So I'll come to you, Honorable Gupeka, now. And Mr. Baloyi, thanks very much for stepping forward. So there's a couple of matters I'd like us to deal with you. So the average cost per claim in terms of the road accident fund, I just need to understand the core of your contention. So 2018, 2019, it was 114,008 rand. In 2019-2020, it was 138,010 rand. In 2020-2021, it was 235,141. A significant jump. It then escalated in 21-22 to 254,531. Is it your so now if you had accepted the same rate, which was closer to normal inflation per year, from 138,010 rand, you'd have gone to 142,426. And where you have 200, so basically where you've got 235, you'd have had 142,426. And where you've got 254,531, you would have had 150,829. Let me look at this latest annual report. So the average value per claim for personal claims has now, in the year ending 2023, it became 346, 406, 517. Is it your contention that the 70% jump we see in the year 2020-2021 is normal? Is there an anomaly there? In other words, you've said professionals are claiming and this kind of thing. And I need to remind you of what I said in the beginning, that where you feel you are speculating, you need to be careful how you word yourself. This is a big jump. 138 to 235 is a significant number. Is it your contention that that should have been expected? Because, you know, that's what happens.
Chair, that's not my contention. I was just citing those as a function of what would not necessarily happen in terms of the inflation of the claims. However, we need to, as I said, the genesis of an inflated claim is not at litigation stage.
I'll get there. We just need to deal with this in pieces. So 138,000 to 235,000 is not inflationary rate. You accept that?
I do, Chair, completely.
So that part of your contention was not true?
No, it is. It's something that is, as I said, it adds to the inflation. It's not necessarily the big portion of it, but it adds to it. So we can't completely rule it out, Chair. That would not be correct.
No. So the reason I gave you the numbers at the historical rate of growth in the average. Okay, so basically you take the RAF's own information historically. You look at the percentage by which the average payout per claim grows. You apply it into the next few years. You've got a level of predictability. The differences I'm giving you are differences that apply the rate at which the road accident fund was having the predictability of what the inflation of the claims would have been. What I'm also sharing with you, so you need to be careful where you say, we talk about inflation, what's normal and what's not, because we can go down this rabbit hole. What we see here is a 70% jump. We can accept 10%. I don't know, maybe if you are feeling extremely generous, 15%. 70 is a big number. This committee has a responsibility to look into why. That's why your answer here becomes very important. So I've given you the inflationary number. The numbers that I'm also giving you are above the inflationary number on the RAF's own data. So let's take that out. Now, enlighten us then, apart from the inflation, what else do you believe would cause it?
Chair, as I said, I mean, you'd find that there are more professionals claiming from the fund. Instead of, say, a farm worker, you're having doctors claim.
Do you know that for certain? What has been the growth in number of professionals who claimed between 2020, 2021 and 2022, 2023?
Yeah, Chair, I wish I'd come here prepared for that question, but I'm not. I mean, we can provide, I suppose, the data as we carry on with this inquiry. But the fact is, there are more professionals that are claiming. The fact is, there are more children's claims. And in the past, you'd find that a black child, for example, would not be getting a quantum that's similar to a white child. But now that has changed, and I think there was some sort of constitutional and a court order that had said that to say that a black child, because their mother and their father and their siblings are not educated, therefore their postulation is that they won't be educated and quantify them at a particular amount. That is not what we're doing. We need to quantify those amounts. We need to...
Honorable Maduna, let Mr. Baloyi speak without interruption.
So obviously then that will also lead to the inflation, or rather the increase of the claimed amount. But Chair, as I said, we need to get to the core of it. The fact of the matter is that at a particular point in time, we realized that I think it was LOE or GDs in the Eastern Cape, or LOE actually, in the Eastern Cape, was getting higher than in Gauteng. So what were we saying then?
What's an LOE?
Loss of earnings. The claimed amount for loss of earnings.
So, Mr. Baloyi, I'm not fighting with you. I am trying to clear up a discrepancy. Don't suppose where I'm going with this question. That's how we're going to have a useful conversation. One of the things the committee is seized with is why it is that the average payout per claim has gone up. So that we save you from, because you're not in the actuarial department, are you?
I'm not, Chair. I'm not.
Okay, so the guys who really would give us this data is them, right? And the claims department. So when I said, Mr. Baloyi, earlier, that if somebody does the work and works with figures, right? It is okay in the committee to say, I'd love to help you. I think this is the reason, but the people who can give you that data and so on. So you remember that conversation. Okay, stick to that. Because we're going to off-ramp and speculate and speculate. I also said at the beginning that if matters are not within your personal knowledge, we must be careful, right? Because this is a big jump, and what you're going to do is you're going to keep trying to justify it and bringing other things. You actually don't have any insight, really, in terms of the specific reason. Somebody needs to come and explain it to us. It doesn't invalidate anything you said. I know about this case, which says if your parents are poor, didn't go to varsity, and you are 12, I'm going to assume that you are never going to be CEO. No, I know that. So all I'm saying is to avoid the area of speculation, right? Stick to what you know.
Yes, Chair, but I think just to get to the crux of what I was trying to say.
Okay, so get to the crux of what you're trying to say, because I do have a couple of other questions of clarification then, because the question that we're asking Mr. Philip, in terms of why it is that there is a court hearing and there's nobody there, it appears you are the right person to help us there.
Yes, Chair. So what I was trying to say in terms of inflated claims is that those claims are inflated at the inception. And this is a function of forum shopping by plaintiff attorneys in terms of expert reports and actuarial calculations. It's not because a matter was, for example, litigated and there was no one there. So that was the crux of what I was trying to get to, Chair. And you're correct, I'm not a numbers person, I'm a lawyer, and I'll leave it at that.
All right. So isn't it the theory, and we'll get to the unrepresented matters. My expectation is that, of course, people are going to forum shop. In fact, the reason the process that Ms. Mthethwa was involved in is important, is to prevent that sort of thing. The forum shopping, right? Because the ambulance chasers will say, I can get you 4 million, right? And they might go around looking for an expert who's going to get 4 million. when actually the matter should be settled at 175,000, right? We agree. This is the very basis for the RAF defending the matters, because the RAF has to defend that, right? Am I correct in saying that?
You are correct with your last statement, Chair, but as Ms. Mthethwa had said...
No, I'm going somewhere. Don't suppose where I'm going.
No, I just wanted to...
I'm asking you the question. So I'm accepting your proposition that there will be forum shopping. It happens, right? Some lawyers might overpromise and so on, and you get this claim of 4 million, when actually it should be 175,000. The very purpose of the existence of your job is that you make sure that the interests of the Road Accident Fund and taxpayers are adequately represented in court, so that that 4 million doesn't become, that 175 doesn't become 4 million. I'm asking you, am I correct in that proposition?
You are correct, Chair.
Okay. When then a forum shopping lawyer rocks up in court and there's no one from the Road Accident Fund to defend the matter at 4 million, what happens?
Chair, are we assuming in this scenario of yours that the matter was never assessed by the claims adjudication department?
No, we're not assuming anything. I'm saying there's a court date. There is a court date. The matter is supposed to be heard. The person from the Road Accident Fund is either not there or does not have instructions. What happens?
Chair, you'd assume that the judicial officer would apply his mind to the matter, go through the reports, and make an adjudication based on that.
Such as what? Postpone the matter?
He can either, I mean, it's within his discretion. If he does grant the judgment, he grants it. But as I said...
No, let's stay there. Let's stay there at granting the judgment. So I'm now following your line of things. So forum shopping lawyer inflating 175 to 4 million arrives there, and now the judge says there's nobody from the RAF, or the person doesn't have instructions. Where do you think that matter settles at then, in terms of the court order that arises?
It should settle, in my opinion, it should settle reasonably. Judges are expected to do what they are mandated to do, which is apply their mind to the merits of matters, not simply become a rubber stamp of what a plaintiff attorney says. If that were the case, where people are unrepresented in court, you'd find many people going to jail for no reason. A judge needs to apply his mind, Chair. That's my proposition.
So in other words, it's not necessary for the Road Accident Fund to have lawyers in court defending its matters, because the judge should just apply his mind. On that logic, that's what you're saying.
No, Chair. What I'm saying is that a judge must apply his mind. The RAF is meant to represent in properly litigious matters. Litigation is meant for litigious matters alone, ones where there are disputes, not ones where we give an offer. The plaintiff attorney wants to test the market. He goes to court and gets a settlement that's equal to or less than what we had offered. And that's what happens. And in those cases where who have given such an offer, they're not entitled to their costs. That's what I'm saying.
You're going around my question. Is it your proposition that the Road Accident Fund, when it chooses, and we're now going to come back to your job and why your lawyers don't rock up in court, if it chooses not to defend the matter, the judge must imagine what your defenses would have been and apply them without you tabling your defenses in court, because you are not there. Is that what you are proposing to us?
Certainly not, Chair. Certainly not.
So what must happen? Because the court can only work on the basis of the facts placed before it, right? You are not there to place the alternative facts before the judge, which are going to bring us down from 4 million to 175,000, and you appear to have the belief that the court must nonetheless have an outcome that is going to suit your preferences. How is that possible if you're not in court to argue your own case?
Chair, it's not my statement that the court must apply or rather defend us in our matters. What I'm saying is that they also have a legislative mandate to apply their minds to matters. Yes, the RAF is meant to be there. Yes, there are matters where we do not have sufficient state attorneys on matters. That exists. That's because we haven't reached critical capacity.
Do you have a responsibility to defend the interests of the RAF?
We do, Chair.
Why don't you?
We do.
No. When you're not there, you're not defending the interests of the RAF. When you're not there, you're not defending the interests of the RAF. Why don't you do that? Why are you shifting the weight onto the shoulders of the court when you have a responsibility to bring down an inflated claim from 4 million to 175,000? You are not there. I don't hear you accepting responsibility here.
No, Chair, we do accept responsibility. As we said, this system and this current operating model, it's in its infancy. I was speaking to Mr.
No, we're going to get there. Believe me. I need to see what needs to happen here now. We need to get to whether for the undefended matters, or where your people don't have a mandate, we as taxpayers and you as a taxpayer, you end up paying more for that claim because there's no one to defend us.
Yes, Chair. But I mean, we can also consider the fact that on such matters where we find that a matter is overinflated and say a judicial officer hasn't applied their mind to it, we have what they call an appeals and rescissions committee, which sits to check whether a matter is justifiable or not and whether we should rescind or appeal that matter.
So, Mr. Baloy, how does it happen that there's nobody to defend RAF matters? You the guy. You the man who's responsible for that. What causes that? And I'm not alleging negligence, okay? I genuinely want to understand that the Pretoria High Court is the busiest, is no mystery. Also have been a litigant. I know you go there, it's busy, right? So it's no secret. Gauteng is the busiest division of the High Court, okay? We know that. So it's no surprise to you. That there will be X matters to be heard in that court should be no surprise to you, especially when you've got the case files. The question we're trying to litigate here with Mr. Phillips, we saw how does it happen. That's why Honorable Gupega asks, why is there nobody to make sure that we can protect taxpayers from these undefended cases where there's no one? So now, we now know that you are the person responsible. What gives rise to this situation where you don't defend matters, and I can pull a few judgments, by the way, because even on the rescission in Pretoria, your folks get there and they say they don't have instructions on the rescission application, so they're now supposed to open the floor and start arguing, and they don't, because they don't have instructions. How does that whole situation develop?
Chair, I wouldn't say I'm the person that's responsible. As I said, I'm in legal administration. In terms of state attorneys being at court, Mr. Brett Phillips would be the one to talk to in terms of the numbers of state attorneys. But I will say this. As I said, Chair, this system is currently in its infancy. We've been working over the past 5 years to make sure that we have a critical mass and numbers in terms of getting state attorneys to the various divisions of the High Court, as well as to far-flung areas where you'll find attorneys taking default judgments in those places. So it's a matter of numbers, Chair. It's not a competency issue. It's a matter
that's why I said I'm not alleging incompetence.
Yes, it's a matter of getting to the correct number. But I'll allow Mr. Phillips, as my colleague, to come in on that. That question I cannot answer.
No, before Mr. Phillips comes in, I still need you on one last question. So what I hear you saying is I don't have enough lawyers.
As yet, Chair, yes.
That's the whole point of this inquiry. So don't be defensive, right? The whole point of this inquiry, among others, is that when organizations in government or anywhere else take such decisions, they must take care to make sure that things don't fall between the cracks. And this testy conversation that you and I have just had now is because it appears that we are not going to get there, right? Because the committee wants you to have enough lawyers. The committee wants you to have enough lawyers. We're not here on behalf of the panel of attorneys. We want you to have enough lawyers. We want you to be able to say the only reason there was nobody there is because they fell ill. You understand? That's what we want for you. Okay? So you need to also help us understand. That's why I said I am not alleging incompetence. But if you don't assist us to understand the capacity issues as a committee, we can't help you in terms of our recommendations. You appreciate that?
I do, Chair, and I think we aligned on that point that there are not enough numbers. I mean, Mr. Phillips had indicated that in his presentation, that I think state attorneys are meant to be around 351, if the number is correct. We currently only have, going into November, 109, and it needs to be ramped up. That's the long and the short of it, Chair. Thank you.
Thank you for that, because in our recommendations, we can now say, Mr. Baloyi and Mr. Phillips need X number of people. Please do something about it. This is where this is going, because we don't get protected as taxpayers. If you can't protect us if you don't have the ammunition to help us with. So again, this is not a fight, but we need to be careful of the propositions, because you think you're defending yourself, but you're cutting your nose. You understand? Yeah, so that's where we can. I don't know if you want to assist further. I'm sorry, members. I felt we need to kind of get somewhere with this so that we can then make the right recommendations. Mr.
Sorry,
Phillips?
Chair, just my closing comment there about there being a ravine between the ending of the panel of attorneys and the state attorneys with not enough people, and that the RAF fell into that ravine. I mean, it is exactly the point that was made here. So,
Mr. Phillips?
Chair, thank you. If I may, I have done some rough calculations in terms of the number of state attorneys. So currently the provision is 216. That's 184 High Court state attorneys and 32 Magistrates Court state attorneys. If I look at the figures that I presented in my presentation, which is 252,000 matters, a comfortable file count for a state attorney would be in the region of about 600 to 700 files. That means I'm 204 state attorneys short on the approved structure.
Yeah, so just repeat those calculations.
And it's not based on science.
No, I know it's a back of a cigarette box.
We currently have in the approved structure 184 High Court state attorneys and 32 Magistrates Court state attorneys. If I had to ensure a comfortable file count of about 600 files per state attorney, 600 to 700 files, I'm 204 state attorneys short on the approved structure, not going into a deep dive on which court they should be for. The majority of the work is in the High Court. But that's the figure that I would look for in terms of a further approval on the governance structure.
All right. No, thank you very much. This is extremely helpful, because then at least we are better informed in terms of what it is that we recommend, right? So that we are adequately defended as taxpayers. So members, the House starts at 3. Can I indulge Honorable Madlala with a round of questions before we break for lunch? Would this be okay? Ooh. Honorable Skosana, we must go and whip.
No, I think you can take both Madlala and Honorable Isaac.
Oh, we can? Okay.
Yeah.
Oh, cool. No, I love that. Okay. Honorable Madlala.
Thank you, Chair, and greetings to the colleagues, the witnesses, and the public. I will try and be economical about time.
You must avoid famous last words, which come back to bite our honorable member, Matuna there. He says, I'm Fisher.
I will try, Chair. An attempt is an attempt. I may fail. So I want to, first start by saying that we may not resolve every issue here, but we seek to understand the challenges. I know that the Chair has explained this. And as an aspirant organizational development fund, I categorize problems according to 3 areas, which is people's processes and policies. And I think in the first instance, there is a general agreement that there's an issue around the legislative framework. So that we put aside, and that is a responsibility of Parliament and other people. And in engaging with other witnesses, we came to an agreement that there's some role that the minister would have played, should have played somewhere along the line, but it did not happen. So I want to start with yourself, Ms. Mthethwa. On your side, it would seem that there's clarity of thought around how the direct claims process worked and is supposed to work, and it seemed that it worked well. So now this is what I want to understand from yourself. As a then senior manager in that space, when you are presented with an instruction, or when an instruction comes through to withhold processes related to direct claims, and as a senior official, you understand the effect of the importance of direct claims, the possible cost implications of not going, of withdrawing from that kind of a process. The instruction seems to have been verbal, as you would you have alluded earlier. I need to understand what was your intervention, because my understanding would have been that as an official, you will then quantify these things into a report and say, look, this is a current process. We note your instruction or the strategic perspective, but currently this is the effectiveness of the process, and these are the challenges of what you are putting before me as a proposition. And this is the counsel that I'm giving in this space. In terms of your own responsibility as a senior executive at that space, what was your intervention in response to the instruction before giving effect to it?
Thank you, Honorable Madlala. You know, it's very difficult, and one would not even know how to phrase an answer to the question you're posing. I don't think anyone had an opportunity to challenge any decisions made during the previous era currently, or this current era. Decisions were implemented, and you needed to implement. And I don't think that's a negotiable space for just for one, regardless of the impact that is there. If your bosses come and say, this is a decision that has been taken and this needs to be implemented, and you ask questions, not that we did not ask questions, we did ask questions. Our people that report to us did ask questions. No one has an answer. And that's, you can go to any extent, no one is an answer of why are we implementing this decision. And without taking much time, Chair, I just want to show you further impact more than the issues of originating claim in that decision. The case managers that were responsible to ensure that the victim that is paraplegic, quadriplegic, bedridden, or comatose, the people that ensure those services are there, that service is no longer there. So it's just the depth of the real decisions that were taken that had such an adverse impact to the beneficiaries and the reason the mandate is there. So the issue of questions we did ask, but there were no answers coming forth.
No, I do get you. I do get the. I think I do get the answer to my question.
All right, sir.
And I have a problem with it, and I'm going to tell you why I have a problem with it. Because if we are saying that supposedly the previous CEO was bullying everyone, right? Let's assume that's the narrative that seems to be coming through. I have a problem with the fact that one person, and I still don't believe it's scientifically possible, that one person in an organization can lead a organization into a detour with competent senior executive beneath not being able to intervene or do anything about it. Because if that is the case, what it means is that even in future, because I'm trying to think of a preventative measure here, what can we suggest as a committee to ensure that you don't have a similar character in future? Because it means if you have a similar character in future and you have such, executives who find themselves unable, and if someone was coming here, and this is not just about you, I'm saying the witnesses that we've been getting, if someone was coming here and saying, this is a report that I drafted in contradiction to this instruction, which I felt was going to be costly in terms of millions of taxpayers' money. I submitted this report with detailed and quantitative statistics of the facts and the effects, and there was no response to this document, or the response was that go ahead as implemented, or was then charged for submitting that detailed report, which is counsel to my senior person. I've worked in administration for about 10 years. And if you give me an instruction over the phone, I put down an email. I say, having noted the discussion where you raise A, B, C, D, E, and F, my advice is that the procedure, the policies of the companies will entail that this is what we need to do. Kindly advise. And I send it back to you as my manager, or as my senior manager, or mayor, or whoever the case is. And I expect then you to write back. And if you then start a disciplinary hearing on the basis of that, I know that it would have emanated from that, and then we can challenge and litigate it. So that is what I wanted to understand. And it seems that your response is saying that you were not able to put a preposition of that nature. You were not able, let me not say, I mean, because of the conditions or whatever the case is. Is that your response?
I did say, and earlier on when I made my submissions, that there was a meeting. We had a meeting as management when this instruction was delivered to us, and it doesn't only end there. I think one of the emails I've shared with the team, the SCOPA team, was one of the emails where I wrote to the COO, and we had a mass funeral due to mass fatality that had just happened. And we were seeking clarity. I think that email firstly, I sent it to the region as the protocol reporting line. What do we do now with this issue since there's been instruction to pause this process? And the region leadership could not respond, the RGM and the senior managers. That email was escalated to the COO's office, whom responded, even if you do this, ensure that you don't even speak about direct claims, or you make sure there isn't even marketing about direct claims. So it was there. It might not have been direct to say, why are we stopping this? However, the communication and instruction and further discussions were there, but we could not get clarity on why.
All right. Thank you. I note your response with regards to that. I want to also follow up on this one issue. You are saying that there was a mass suspension. So there was a number of people that were suspended for default judgments, or where within 180 days there was no processing of issues. You also say in the similar statement that despite your own investigation or finding, there seemed to have been a determination that these people needed to be gotten rid of, and ultimately they were got rid of. I just need clarity about that, because that statement seems to suggest that there were illegal dismissals which were administered by somebody. The process began with an end. And I need to know who administered those dismissals, because if I am tasked to do an investigation on the people that report to me, or if I'm told to suspend them, and okay, it's fine, we can do a preliminary suspension while I conduct an investigation. If I find that there's no fault to them, but it's the structural and systematic flaws in the system, I write back a report that there's no need for a disciplinary measures, and who then instruct who to say proceed, discipline, and dismiss. I just need to the clarity on that part.
Sorry. In a normal organization, yes, of course, there's or in normal circumstances, of course, there will be proper procedural issues when it comes to employee relations, right? But in the case of RAF, what's been happening currently, ER will charge, they will witness in that case, they will initiate that case, they will prosecute everything, ER, without even the presence of the manager responsible for that person as per to the policy. That's basically on facts of what's happening currently. So if you have ER that charges a person and the allegations come from ER, right? It's not the direct line manager as per to the policy. And the very same ER will do they will be prosecutors in that case. And the very same ER will dismiss that person, not the direct line manager. So everything is not being done within the policy when it comes to ER since 2020. Nothing has been done according to the policies that govern ER or HR in RAF.
All right, so you were not involved. That investigation that you did where you found that it was systematic issues, was just your informal thing on the side, or it was part of the process, or you were just given the letter to suspend and then they did every other process leading to dismissals? I just want to understand your role, and also how is this finding that you are saying that you came to that these were actually systematic issues?
I was definitely involved. I'm not gonna remove myself from the process because I was part of the process because I did the investigation. But the ER officer will say, you are not being asked. We need these people to go give us numbers. You will of course instruct the manager responsible to say, please execute, here's the list, they want names.
Okay, so you're saying that you did an investigation. The investigation found that this was no fault to employees. But on the basis of that investigation, a hearing was conducted. I want to understand the process flow. Now, we've done an investigation, we've concluded it comes with some recommendations or whatever the case is. But on the basis of the same report, the employees were charged and ultimately dismissed.
No, not on the basis of the report. Remember, the report for me is to try and exclude what could have been the issues leading to these allegations that came into these misconducts or the reasons people need to leave. So that was my approach, but that made no difference. When I came in, there was already a list of employees, the names, and the number of claims or payments that they had not requested that had court orders. Right? Now you want to understand why half of the department are implicated. That's the first thing you want to look at as a manager in the team. What could have led to this? Then you find out the flaws. Then you try and discuss it. And you are told to say, these names are already out. These people must go. So that investigation does not even make a difference.
Okay, all right. Let's pass on that. I think I hear you. Were there any further dismissals? I want to assume that obviously when you then dismiss those employees, the load becomes even more, like you are saying. So there'll be more of the same allegations that they were charged for, exerted upon the remaining employees. So were those other employees also charged for not for default judgments and not meeting the 180 days and so forth?
Yeah, by the time I left the organization, yes, definitely, most employees were charged and they were dismissed.
Okay. Mr. Phillips, I've got a few questions for you.
Sorry, Honorable Madlala, can I just second? It was not only in the region, it was national. That issue affected most handlers nationally.
Okay, thank you. Just a few questions for Mr. Phillips. I want to understand, at least Mr. Baloyi came in, clarified the part that you guys are responsible for managing this litigation process, the assignment of attorneys and all of that process, because I was going to come to that because initially it seemed as if there's nobody who is responsible. And I think, Chair, thank you for that conversation, because I was also a bit disturbed by Mr. Baloyi's statement that they are managing, being tasked to manage and managing are two different things. Managing means there is a good process flow and things are happening. And there is a challenge which is admitted on record, which relates to issues outside your own capacity or ability to some extent. So when you're saying I'm managing, you say we could, I'm handling matters. But when you are tasked to manage, however, these resources and other factors make it difficult for you to actually do it. It's a different case altogether. But I do have this one question, and I'm a firm believer of the maximization of available resources. We may not have enough attorneys, but structurally and systematically, how are we using the available resources to mitigate and ensure that we deliver to the best of our own ability? So if we have an opportunity to defer cases where we can be able to pick up through the system that they are double booked, attorneys and all of that beforehand, so that we ensure that it may take longer for us to finalize matters, but at least where there is a date and there's a person, there is always a person and the person has a mandate. That is within our own capacity, I think. I think if we have a proper system, we can be able to do that. And Mr. Press, I think, said there's a process of finding a system of some sort. I want to just understand then what had been your role between the time that you employed until now, that there's an effort to find a system. What has been your intervention and what have you put in place to just ensure that there's maximization of these state attorneys in terms of ensuring that in as much as the dates, we can get a date, I mean, a proposal for a date today and have it in December, whatever the case is. But where there is a case, there is an attorney, and that attorney has a mandate. It may be from different regions. It may be through not even a technologically advanced system. It may be through a simple thing as a registering on a spreadsheet that there's this case, it relates to what APC and it's scheduled for this date, so that gets scanned to the head office or to a central coordinating space, and the meeting is held where these matters are dealt with. We should be sitting next month. It could be anything, but a mechanism that ensures that ultimately when there's a date, there is an attorney, and that attorney is not double booked. What have you put in place during your time of employment to at least move along those lines? Thank you.
Thank you very much, Honourable Matlala, for the question. And I think it comes back to my original answer when I first joined the litigation team in November 2021. We are very acutely aware of the benefit of having court rolls at an early stage. So between myself and Mr. Baloyi, we are in several engagements with the judiciary around the country. We attend what is called the Provincial Enhancement Efficiency Committee meetings, and they're generally chaired by either the judge president or the acting judge president of the division that we're in. And some of the smaller divisions, obviously, we are able to get court rolls for an entire term of the court year. And those court rolls are then distributed to the operations space so that operations is able to understand the volume of work that is expected from a specific region, and they are able to work on those files in advance of the process. Obviously, the state attorneys are allocated through the LMS system, and if there are matters that slip through the cracks, obviously operations is expected then to allocate state attorneys, for instance, on former panel matters, to ensure that we now have knowledge of a trial date, that those matters can either be settled in advance, or if there are litigious disputes on matters that, for instance, could require a witness to be subpoenaed and preparation for instance, a merits trial, that can be effectively done through our central investigation units, so that we are giving the matters that we are aware are going to trial the best preparation that's available for that specific date.
I think you're answering like a lawyer.
And it's your last one.
Not like a manager of the process. You are giving me quite a very long answer, but let me leave it. I think I get the answer from the answer that you are giving me in relation to that.
Your last one, Honourable Member.
Is 15 minutes already up?
You're actually on 19.
Oh, okay. No, I wanted to also check, because you said that you were there during the process of the panel attorneys, right? And I want to check in terms of your own planning and also experience, what you find effective between the two, and between the panel attorneys, how it was functioning, and the state attorneys. And then the last question is, what then happens as a repercussion, as a consequence management for failure of attorneys, whether internally and also to attorneys, for failure to present themselves? I see where they present themselves and they don't have a mandate, because that can't be their fault. But where they simply just do not present themselves, what do you then do as a consequence management for within RAF as well as in relation to that particular attorney? Because it comes with a cost, obviously, which is part of our concerns. Those last two will be definitely the last. Thank you from me.
Thank you for those questions. In terms of the system that was in place when I was first in the organization with panel attorneys, obviously, and this is the model of the state attorney that we are trying to capacitate. There was a whole back office process linked to a panel attorney representing on a matter. The way in which files were allocated to panel attorneys was there was an algorithm, and you would get 100 files, whether you had capacity to deal with those 100 files or not. So when panel attorneys were handling matters at roll call, you could have 10 panel attorneys in court that day with 15 matters each. Now, the system obviously worked in such a way that in the event of instructions not being provided, and a practice arose in the high courts around the country during the panel times, where counsel would get up and tell a judge, we don't have instructions from the RAF, but we have assessed the matter and we feel that the matter is worth X number of rand, based either on the plaintiff's reports or on the expert reports that we have. And the process then ensued where judges would grant what they called having heard counsel orders, distinct from orders which are by agreement. Now, that allowed for effectivity to some degree, albeit in the absence of instructions from the Road Accident Fund. But at the time, the service level agreements that were in terms of which the panel attorneys were appointed, there were breach provisions in terms of which panel attorneys could be charged for breaches of the service level agreement. And there was an agreed formula that was calculated for whatever the nature of the breach was, that you were charged with failure to, and I'm speaking under correction, I'm not 100% certain the full extent and nature of the breaches, but if you didn't provide an opinion to the fund within X number of days before a trial date, you could be charged with a breach and you would be invoiced accordingly. When it comes to state attorneys, I'm hopeful that if we capacitate the state attorneys like you would a panel firm, you will have effectivity across the board. That's very much what I'm aiming at. And I think it also comes back to the question that I answered earlier, Chair, around increasing capacity for the support staff as well. If we increase the capacity of the state attorneys and we add another 200 odd state attorneys to the structure, we would need to add another paralegal and another legal secretary for each of those designations. Does that answer your first question?
You can move to the next question. We're out of time in any case.
Please, can you just remind me?
No,
of your
the second
question?
one was what are the corrective measures? So, in an event that an attorney does not present himself or herself for the matter, and we know that it's got financial implications.
Yes.
So, what have you put in place to ensure that it does not become a continuous or habit, or even a deliberate issue? Because if I'm colluding with these whatever people, I can decide not to pitch. I know that they're going to get an award. So
Yes.
what have you put in place to ensure that there's some measures at least to curb that from
So
happening?
my department has recently amended the performance scorecard of state attorneys, and there is now an allocation on the performance scorecard which speaks to default judgments and the number of default judgments and the reduction of default judgments. So we've completely re-engineered one of the KPIs on the performance scorecard, and state attorneys, in the event of not being able to provide a reasonable explanation for non-attendance at court, there will be a disciplinary process which they're subjected to.
Thank you. So I was going to go to Honorable Isaac as proposed. Thank you, Mr. Philip, and thank you, Mr. Baloy, and thank Ms. Mthethwa. But we are under pressure, so we've asked for catering to be provided for members and our guests. They tell us they're going to close at 2, so we don't want fruitless and wasteful expenditure. So can we do that? So we'll convene after the plenary when we come back. You look disappointed, Honorable Isaac. I thought you're a man of endurance.
Sure, with due respect to you, but I am awesomely disappointed. I'm shattered because unfortunately I'm going to be a presiding officer after the plenary in terms of another election. So and I was so hoping that I could interrogate my questions, but Chair, that's fine. I respect that. I may hand them over to my colleague.
You can do that. You can also what some members do if they won't be here. There are some pertinent they do. By the way, not all the questions I ask come from me. So members WhatsApp me as well, and they say please ask about this and that. You can also do that. Honorable Atkinson is fine.
I'll hand them over to Honorable Atkinson.
Okay, you don't trust me, I see.
Yeah, Chair. No, Chair, at least I did my part. I fought for him. Because both of us are coming from Mpumalanga. So I fought for him. I did my part.
But he gave it to the wrong member.
Okay. Okay, no, thank you very much. Ms. Mthethwa, Mr. Baloy, and Mr. Phillips, there is a canteen downstairs, but the colleagues will show you where that is. And then You can go see Cape Town in the meantime, and then we will reconvene in the early evening. You look shocked.
No, you can leave your stuff.
Yeah, you can leave your stuff. There's always somebody here. Just don't leave your cell phones.